Okay, so the court. All right, good morning, counsel. Good morning, TikToker. Miss Olson, do I understand that you have a couple of housekeeping matters to raise first with me? Ms. Olson, yes, Your Honor. First, with respect to Exhibit 34, that was the one with the redactions last night. We did provide unredacted copies to TikToker. The court has unredacted copies. We provided those already. The two redacted entries were treatment for Professor Scofield's daughter, GC, who is obviously a minor, but also we're not seeking damages related, obviously, to any treatment for GC. So we would propose I can just do it on redirect to offer that again. The court. All right. And TikToker, having now been provided with the unredacted, I don't know if she's been provided with it before last night or not, but having now been provided with the unredacted version of the document, do you have any remaining objection to its authenticity? TikToker, no, sir. Court, okay. Then I'll allow you to ask those questions and answer or enter into evidence when you wish. What else? As long as it's after 11:30 a.m. Mountain Time, I'll be back. Okay. We'll see. Maybe we'll do like a late night stream. We'll get like all our cozy vibes going. Maybe we'll do that. Okay. Mr. Carone. So Mr. Carone is another attorney. So I think you'll see him talk today as well. But Mr. Carone and Ms. Olson are the two main, and then Ms. Bibbs is, I think, their like third helper or paralegal. I'm not sure if she is. Well, I could probably look. No, I'm not gonna look. I don't really care. But that's who Mr. Carone is. Okay. Mr. Crone, Your Honor, we anticipate that Dr. Rebecca Talent will be called to testify today. I know Your Honor has already addressed her qualifications and certain aspects of her opinions that she's allowed to testify about at this trial. I'm just curious whether your preference is for me to again ask for her to be recognized as an expert on those areas in open court, or just along with my questioning. The court. PJ party. Yeah, we could. I'm down to do that. We'll just get cozy. I'll get a better chair too, because my chair's not that cozy. We won't do it too late. I'll start like 8-ish, and we'll try to end by 10. Will I get done by 10? Probably not, but we'll try to end by 10. Because I always say, I'm like, oh, it'll only be like a couple hours, and then it ends up being like 8. But the court. No, my preference is not for you to ask for me to recognize her as an expert, but for you to go ahead and establish her credentials and qualifications as an expert. And then you can set your direct testimony, and then ask for her expert opinion. Mr. Carone, thank you, Your Honor. The court. All right, and if we need to, before she takes the stand, if we need to remind her as to exactly what I've allowed her to testify to and not allowed her to testify to, I will provide those because I made some notes so we can address that when she's about ready to take the stand. Mr. Carone, thank you, Your Honor. The court. All right. TikToker, do you have any preliminary matters that you want to raise with me? TikToker, no, sir. I just need the connection for my laptop. The court, all right. Miss Pfeiffer, Miss Tate, do we have that ready for her to go? And while you're doing that, TikToker, I want to just briefly talk to the parties about the informal jury instruction conference today after court. It was my intention to provide the parties the court's draft prior to the 3 p.m. informal conference. Last night we received TikToker's 3 proposed instructions. I want Ms. Olson, if you can, at 3 before we start the informal, I'll hear any comments or arguments they have related to those because they were late. We didn't have time to digest them beforehand, but I want to hear from you at 3 p.m. Why? I have a genuine question. Like, and this is not to be rude. This is not to be snarky. Like, it is just a genuine question that I have. If you were given, if you guys left around like, what was it, 4, 5 maybe, and you were given until 8 o'clock at night, why did you submit them later than that? Because they don't even say when you submitted them. They just say that you submitted them late. I'm so curious to know when you submitted them. Actually, I'm gonna look. Um, cause to me, um, proposed jury instructions. Here they are. Okay, so you. Do I have to get into Pacer? I might have to get into Pacer. To see the exact time. Dang. Okay, never mind. I was like, oh, I'll just look. Nope, never mind. I won't. Never mind. But like she has submitted almost everything late. So I'm just curious as to why. Like if you have all like say you submitted something on May 1st and you have until May 11th. I get that you have a life outside of everything, but if you, especially with like some of this stuff, if you know, then why are you doing okay. Okay. Um And then what we'll do is Mr. Gordon and I will go back to chambers. We'll reconstruct my draft final, and we intend to provide a copy to those parties along with the model jury instructions, both Ninth Circuit and Idaho, upon which they are based the templates so that the parties can look at my final version, compare them if they wish to the templates. And then you'll have the opportunity to do with Mr. Gordon is to wordsmith or propose any possible changes to the version that I've drafted, and then he'll bring them back to me overnight and we'll finalize them. And then tomorrow we'll have the final formal jury instruction conference. That'll be on record with the parties having the opportunity to make formal objections to any instructions that are given or not given. Any questions about that, Ms. Olson? No, Your Honor. Any questions, TikToker? No, sir. All right then, Professor. Do you want to resume the witness stand, please? And then, Mr. Gordon, would you go ahead and bring the jury in? Jury enters. The typical questions. Professor, I'll remind you that you're still under oath. TikToker, you can resume your cross-examination. TikToker, thank you. Cross-examination resumed. Okay. Oh, yay, the shit show. Let's see. Question, Professor Scofield. Yesterday we left off at you stating that your boss was supportive of you from the onset of this incident. Correct. Can you please remind me of the dean's name? Yes, that would be Dean Sean Quinlan. He's the dean of the College of Letters, Arts, and Social Sciences at the University of Idaho. And can you recall how supportive he was of you during that time? Yeah, so I stated in my previous testimony, he's who I first forwarded the email to and who I spoke with on November 24th of 2022 about appropriate steps that we would take, including reporting it to the police and working with U of I security team. After that, we did fairly regular check-ins, sometimes daily, sometimes every couple of days, throughout December, and we were discussing wrap-up of the semester, any concerns, things that were coming in on that side, and then any options for the following semester as I weighed personal safety on campus. Thank you. Question, around that time, you stated that, if this is correct, please let me know, that you also filed, did you talk to the Moscow Police Department when my videos came out? Correct. What day was that? I called them on November 24th. What did they tell you on November 24th? As I stated previously, I simply left a message first on the non-emergency line that there were allegations being made against me and provided the TikTok information. And I said, you know, if a police officer is available to speak, here's my information. So a police officer called back a while later and said he had reviewed all the videos. Again, it was news to me that there were, I think he said 10 videos at the time, or around 10 at the time. And we simply talked about that they were aware of the situation, that they would reach out to me if they had any follow-up questions regarding my involvement of these allegations. Yeah, the question and answer thing is kind of crazy to me. Just wait until the TikToker is interviewing herself. um, Question: do you know the name of Answer: I don't remember the name of the police officer I spoke with. Question: did they ever get back to you? Answer: they never responded to after that initial conversation. The Moscow Police Department never again reached out for questions for me. Question: thank you for that. You stated you received phone calls from family and friends, your parents, after the TikTok videos. Were they supportive of you immediately after the TikTok videos? Answer: our close family and friends, as they began seeing it in their fields, finding out about it, yes, we received a lot of support from our family, our friends. Question: thank you. Clarify the email you got. That was a student from an alumni that warned you of the videos. Answer: yes. So in the initial email, again, I did not recognize the name. It had not been a person I worked with. There was maybe a sentence or two that simply said, I'm an alumna of U of I. I think you should watch the video linked below. Question: and your best friend who's going to testify, Chris. Answer: Chris Hansen, yes. Question: Chris Hansen, he also supported you immediately from after receiving the videos. Answer: yes, he did. Question: okay. Clarify these dates for me, please. On November 24th, 2022, you had the support of your job and specifically your boss, the dean, yes or no? Answer: correct. Question: on November 24th of 2022, same day of the videos, you also had the support of your family and friends. Is that correct? Answer: at that point, the only family and friends who knew was my husband and my sister-in-law. Question: and oh, okay. November 24th, 2022, you had the support of your husband and your sister-in-law. Correct. Others were not aware. Correct. To my knowledge, they were not aware. Thank you. On November 24th, 2022, your best friend was also supportive of you. Yes, he was. Question: clarify. By December 27th, 2022, Moscow Department, and you testified to this yesterday, you just want to I just want to go over this again. That Moscow Police Department made a statement on your behalf stating they did not believe you were involved with the murder of the 4 students, and you read that yesterday. So it is fair to say by December 27th, 2022, Moscow Police Department released to the public that you were not a suspect, showing that they supported you, yes or no? Answer: I would say the word support is pretty subjective there. I think they were saying I was not a suspect. Question: by November 24th, between November 24th, 2022 and December 27th, 2022, there was no threat of police investigation from Moscow Police Department. Or would you say that after December 27th, 2022, there was no threat of being investigated by Moscow Police Department? Ms. Olson, Your Honor, I'm going to object as to inherently calls for speculation. The court, she can answer as to her understanding of whether it was you perceived that you were going to be investigated going forward. Answer: as so prior to the 27th, I think that I should state that I made very clear I was willing to be investigated at all times before and after this statement was made. I was not concerned at all about an investigation, so I would not say that I was under threat of an investigation. Question: okay. Answer: either before or after that statement. Question: thank you. As of November 24th, 2022, you were not concerned that you were going to be investigated by Moscow Police Department. Answer: yes, I was not concerned about what the investigation would find because the allegations were false. But I was concerned about the misuse of public resources on investigating someone like me who is wholly unconnected. The court, Miss TikToker, is your last question you stated as of November 24th, 2022? TikToker, yes. Court, all right. I just want to make sure that we have the right time frame. Question: on the date you contacted Moscow Police Department, you were not concerned that you would be investigated by them, yes or no? Answer: I offered to be investigated by them. Question: yes or no, were you concerned? Answer: was I concerned? No. Question: thank you. Answer: I was not concerned about an investigation. She likes to talk over people. Question. By November 24th, 2022, you stated you had the support of your boss, the dean. At that time, were you concerned that you would be investigated for having a relationship with a student? Yes or no? Answer. No, I was not concerned about question. Thank you. Answer. An investigation. I was concerned about the suspicion that is inherent to an investigation as U of I policy states. Question. You stated your boss was supportive of you, helping you throughout this entire ordeal, and that the same day you emailed him a copy of the video, and he was not threatening to investigate you, correct? Answer. Again. Question. Yes or no? The court. TikToker. You have to let the witness answer. TikToker. Okay. Answer. Again, the threat was not the investigation. It was the suspicion that is inherent to an investigation as per U of I policy. I was utterly willing from the get-go to be investigated because these accusations were false. It was not the actual investigations that were concerning. It was the rapid spread of the lies that you were saying online that were concerning because rumor has as much impact on reality. Question. Let me restate the question. Yes or no, were you concerned or worried that you would be investigated for dating a student on November 24th, 2022? Ms. Olson. Objection, Your Honor. This is asked and answered and at this point argumentative. TikToker. I asked for a yes or no answer and she's speaking on other things. What? Okay. The court. I will overrule the objection. You can ask a question that calls for yes or no answer. But then, Ms. Olson, you'll have plenty of latitude on redirect to ask more questions. Ms. Olson. And I'd also object on argumentative grounds, Your Honor. The court. All right. Overruled at this time. Re-ask your question, TikToker. On November 24th, 2022, you were not concerned that you'd be investigated by the University of Idaho for dating a student. Yes or no? Answer. No, I was not concerned because the allegations are false. Question. By July 24th, or July of 2024, did you have the financial support of the Idaho chapter of the American Federation of Teachers? Ms. Olson. Objection, Your Honor. Relevance. TikToker. I'm asking because I can have follow-up questions on who that is, their teachers union. Court. Hold on, TikToker. What's the relevance of whether she had the financial support of the American Federation of Teachers? TikToker. Well, I was just being specific regarding the financial support, but I can state support of her unions, her professional career, her boss, her affiliations. The court. Ms. Olson, is your objection that the financial support that she may have received from this organization does not go to damages in this case? Ms. Olson, it is, Your Honor, but if we could, I'm happy to approach. I think I know what she's going to get into. The court. All right, let's approach, please. And sidebar. All right, we're going to dig into the sidebars. Okay. Oh, I love sidebars. Sidebars are so good. Okay, so Ms. Olson, Your Honor, a portion of Professor Scofield's legal fees she raised through a teachers union and through a GoFundMe. I don't think how she has paid for her legal fees or hasn't paid for her legal fees in this case are relevant at all. The court, because they don't go to damages. Ms. Olson, right. We're not asking for attorney's fees in damages. It's not a component of damages. It's something you have to ask for separately. TikToker, I'm not intending to mention anything about legal fees. My purpose is to establish that damage to her professional career did not occur because she was supported by the union. She was supported by her boss, students, alumni, and stakeholders in the University of Idaho. The court, in that line of questioning, is completely fine, but the question you asked was, did she have the financial support? So if you stay away from this financial support and just ask for the moral support or whatever you want to phrase it, that's not financially related. because as Ms. Olson argued, the financial support for attorney fees is not an element of damages, so that's not something about it. That's not something that it goes to in this case. So if you want to ask just about support generally, you can do it that way. TikToker, and my next will be the GoFundMe support for strangers and people in general online. Ms. Olson, the GoFundMe page, as I understand it, was done by a friend of hers, and it was that person then provided the money for legal fees. The court only legal fees. Ms. Olson, that is my understanding, Your Honor. TikToker, no. It does state that the remaining of the fees, she could use it towards donations of some type. The court, I'm going to allow that, Ms. Olson, but I will allow you to clarify that on to redirect examination. That the money was used or not used exclusively for legal fees, but a public GoFundMe site, I think she's entitled to ask about that. You can clarify it on redirect. Ms. Olson, just to be clear, Your Honor, we object. This question is getting well beyond the relevance into damages, and it is the court. And I don't know enough about the GoFundMe. I completely understand your point about the American Federation of Teachers, but the GoFundMe is a private public-facing call for money, and I don't know what it was used for, so I'm going to allow that. End sidebar. The court. All right. That objection to the previous question will be sustained, and you can proceed as we discussed at sidebar. TikToker, yes, sir. Question. Professor Scofield, by July 2024 or before, did you have the support of Idaho chapter of the American Federation of Teachers? I'm not certain how to answer. I'm not certain how to quantify support, certainly. So the AFT is the teachers union that any U of I employee can join, and certainly there was alarm within the union about these types of attack on faculty. And so I think that there were members of the union who were supportive of my attempt to stand up to this type of behavior. Question, thank you. Did your support begin in 2024, or did they also support you beginning November 24th of 2022? I did not speak with my union in November of 2022. Question, did you know when you're perceived to receive their support? Answer, I don't remember when the support began. I don't recall there being a moment there where union members said, we support you. Question, thank you. By July 2024, did you have the support of the Idaho Federation of Teachers? Answer, again, so that's the larger Idaho chapter of our union. Question, thank you. Answer, and again, I would say there were certainly members within the Idaho chapter that supported my stance. Question, by July 2024, did you have the support of the National Legal Aid Committee with the American Federation of Teachers? Answer, again, I don't recall a date range of that committee within the national level. I don't remember a date. Question, okay. Let me ask this question because I've never been a part of a union. Can you inform the court of any? Do they have the power to harm your career or enhance it in any kind of way? Answer, no. Idaho is a non-bargaining state, so teacher unions are more places to gather to talk about concerns. So I would not say a union in Idaho or even the national level union would have a significant say in the trajectory of your career. It's an academia more based in your field of study rather than a union. Thank you. By April 2023, did you have the financial support of a general public and just general support of the general public? What? Ms. Olson, objection, Your Honor. As to the form of the question, it's vague. The court, that'll be sustained if you can break that up and rephrase it into two questions. TikToker, by April 2023, did you have the financial support of people online, strangers, general public? Ms. Olson, objection, Your Honor. She's again asking about financial support. That'll be overruled if you can just ask more specifically. Okay. In April 2023, did you have a GoFundMe page? We had a friend who was concerned who established a GoFundMe to help us with legal fees. Is this person associated with the University of Idaho? No response. Question, to your knowledge, if you don't know. Answer, I don't understand the relevance of my friend's job to her willingness to. Okay, support us. Question, the person who set up the GoFundMe, was it one person or a group of people? Answer, the person who set up the page itself was one person. Question, was that one person a colleague at the University of Idaho? Answer, they're not a direct colleague in my department or college. I do not work closely with them at the University of Idaho. Why does that fucking matter? I'm sorry, but why does that matter? I get her questioning, but like, why does that matter what she does? I just feel like, what is that? What's that freaking meme that I was, what do you mean? What do you mean? But it's just like, why does it matter? Why does that matter? Question, is it true that the person who set up the GoFundMe page works for or is a stakeholder at the University of Idaho? Answer, I'm unclear with the use of the term stakeholder. Question, stakeholder just means a student, a teacher, an investor, someone who's invested in or works with or affiliated with the school, a customer. Answer, yes, this person is employed by a different college at the University of Idaho. Question, thank you. TikToker, I would like to present the plaintiff exhibit, defendants exhibit number 519. And TikToker, did we have a marked set of your exhibits? Yes, sir. All right. Let me just make sure I have them. Have you submitted them electronically, or are you going to use the Elmo? I'm going to use the Elmo because I don't have the option for screen mirroring. It's not showing the option. All right. Have you tried the Elmo before? Oh, and then she shows me the GoFundMe. Do I have the GoFundMe? I don't think about it. I don't have it pulled up. Hold on, let me see something really quick. But this is her GoFundMe, so this is 519 technically. So I blocked out donors and stuff because I just felt like it wasn't really relevant. But they gave an update on what was all going on. Oh, and then it was just saying that words of support. Yeah, it even says here that, like, the University of Idaho chapter have moved to contribution for legal fees. So they're pausing donations because they're giving legal fees. Yeah. So. Yeah. So that. Yeah, I think it's another instance of the TikToker not thinking that what she says on the internet. Yeah, probably. It's a little weird to me, too, just in general, of like, you know, you obviously can see that, like, you're kind of not winning the argument that you want to win, which is a weird thing to say. But if you aren't winning the argument, just drop it and move on. But yeah. So she asked to publish it to the jury. The court grants it. And then question, Professor Scofield, do you acknowledge that $22,741 was raised by essentially colleagues, strangers, people in the general public, is what I mean by that on your behalf? Ms. Olson, objection, Your Honor, as to the form of the question regarding her knowledge about who may have donated to the GoFundMe. The court, if she knows who donated. Answer, I'm unsure of everyone who donated to the page. Question. Did you read the words of support from the people who donated to you? Answer. Some of those comments were forwarded to me to try to help me get through this. Question. And you clarified that it began in April of 2023. Answered. No response. Question. Let me ask you, do you know what day the GoFundMe was published? Answer. I don't remember what day. It's on the paper. It says July of 2024. Question. It was updated. Sorry, just to clarify. Answer. Oh, I'm sorry. Question. It says July 4th, 2023. Do you recall that being the day the GoFundMe began? Answer. Again, I don't recall a specific day. Question. I want to show you a comment from some of the supporters. 2 years ago would be 2024, 2025-ish. Oh, why are we blasting people? Were you aware of that comment of the support? I generally don't know if I'm aware of comment or support specifically at the time. Why are you... Oh my god. Why are you blasting people? um... I don't recall being aware of it or not to. Okay. Question. Okay, thank you. When people donated you $22,000, why didn't you feel the need to read their comments? Ma'am, argumentative. Ms. Olson, objection, Your Honor. The court sustained. Ms. Olson, relevance or argumentative. The court sustained. It's argumentative. Oh, okay. Question on this is a different topic. Thank you for your answers on the support questions. On December 21st, 2022, you filed a complaint against me, correct? Correct. In that complaint, you acknowledged that I had never been to Idaho, and you were aware of that, correct? Correct. Did you acknowledge that none of my TikToks were about your kids? Ms. Olson, objection, Your Honor, on foundation grounds. I think there's not been foundation that Professor Scofield watched every single one of the TikToks, so maybe if the question were, do you acknowledge that none of the ones that you watched said anything about your kids? The court. TikToker, I'll reword it. Question. Do you acknowledge that none of the TikTok videos that you watched that I published were about your kids? Answer. I acknowledge that none of your TikToks that I watched mentioned my kids by name. Question. Did I mention in any videos, did I mention your kids generally from the videos that you watched? Answer. From my recollection, I don't believe you mentioned that I had children. Question. Thank you. Do you acknowledge that from the videos that you watched, TikToker did not threaten to cause harm to you or your family, to include your kids? Answer. I do not acknowledge. The harm implicate in the videos, the harm meant to my life was in every single video. Question. I'll rephrase the question. From the videos that you watched, you acknowledged already that you did not see any videos of me even speaking on your kids. So I'll separate the questions. With the videos that you watched, you acknowledged that TikToker did not threaten to physically harm your children. Answer. I acknowledge that in none of the videos that I watched did you threaten to physically harm my children. So that has not been our argument throughout this case. Okay. Thank you. Thank you. Do you acknowledge that TikToker in the videos that you watched from my TikToks, that I, TikToker, did not threaten to cause you any physical harm? Answer. I think that would depend on how we interpret threat. Question. Let me interpret it for you. I don't think you can, so I can clarify the question. Threat by physical violence directly and experienced. Threat by physical violence directly witnessed by you, from me to you, to your family or close relatives or friends. You. Oh, she's using the DSM-5. She's trying to use the DSM-5 to get away with... Oh, okay. Okay. Thinking back through all the ones I watched, I do not believe you stated a specific intent for physical harm, though there are other alarming indications of hyperfixation and concerning aspects that certainly put myself and my husband on high alert for potential physical threats. So the answer is no. You acknowledge that I did not, in the videos you watched, threaten to physically harm you. Yes or no? Again, I acknowledge that from the videos I watched, you did not make a statement of intent to physically harm me. Question, thank you. Do you acknowledge that, or maybe you're not aware of this? Do you acknowledge that you and or your counsel monitored my social media accounts from the posting of the videos until current day? Answer, I have no awareness. Question, were you able to view the exhibits prior to this? Answer, yes. Question, in those exhibits, do you acknowledge that there are exhibits of me on social media from my Instagram, Facebook, YouTube, and TikTok pages? Miss Olson, objection, Your Honor, relevance, TikToker, I'm trying to get there. Miss Olson and Foundation as to this witness. TikToker, I'm trying to get there. The court, can you rephrase the question? TikToker, my first question was, do you acknowledge that you or your counsel monitored my social media accounts from the posting of the videos until current? And she didn't answer that. And I'm going to sustain the objection. What's the relevance of what her or her counsel did? TikToker, the relevance is they knew my location wasn't in Idaho. The court, why don't you just ask the witness if she knew whether your location was outside of Idaho? You can tell, especially on the second day, that he's starting to get annoyed with her. Question, from November 24th, 2022 until current, were you aware that I had never been to Idaho until this trial? Answer, yes. From November 24th of 2022, we knew you were not from Idaho. We knew you were not currently in Idaho, but we also know you could easily get to Idaho. Okay, would TikToker, I'm sorry, me, I have to speak to myself in third person. I'm sorry. With me being out of town and you having the support of your community professionally and personally, with you withdrawing, which was your word yesterday. Yes or no? You withdrew from social media. What? Answer. I think that anyone would acknowledge that it is very hard to not watch what is on social media, even if you yourself are not promoting yourself or posting. I was still aware of what was happening and what was being said, and I was still very much aware of what was being posted. Question. Okay, I'm sorry about that, but you said you were not posting on social media, but you were active on it, but just browsing as a viewer. Is that correct? Answer. Yes, I will say that. Like, I have never had a TikTok account, so this was really browsing with family and friends who would send me things. So I did not have to actively seek out what was being posted. Question, and I'm speaking not to just what was being posted, your use of social media on Facebook. You said you used Facebook. You said you withdrew from posting on Facebook. Is that correct? Answer, by and large, yes. I don't remember the posting patterns of all last 3 years, but I essentially not posted anything about my kids any longer. Yeah, I just withdrew from the potential spaces of contact due to the negative interactions I was having. And lastly, on regards to social media, do you acknowledge that you already acknowledged that you received the support of your professional community? You've acknowledged that you've received the support of your personal community. With that being said, your decision to withdraw posting from social media has nothing to do with the lack of support. And then answer is the professor. So the A is professor. And she said, I would say it would be generous to interpret the people who were supporting me as the full support of my entire career community. That's a massive statement. And again, the support of a community is also incredibly subjective. My close friends and family who knew me, who knew my values, who knew who I am, certainly supported us. Question as well as answer my question. Sorry. Answer. My withdrawal from social media had everything to do with the allegations that were being made against me and wanting to shut out as much as humanly possible any additional areas of contact. Question. Yesterday. Clarify your testimony that your boss helped you to privatize your social media accounts. Answer. That was the U of I security team suggested that as sort of standard protocol, when faculty are doxxed or when information is shared about faculty outside of official chains, that they take certain steps to, again, limit where people can reach them. And one of those suggestions was to lock down social media. I had to inquire as to what that meant, and they said how to find the social privacy settings on Facebook. Answer, correct. What the fuck? Okay. That was around November 24th, 2022. Answer, that was on November 24th, 2022. Question, on November 24th, 2022, did you privatize your Facebook page? Answer, I think I did successfully. I think I followed instructions. Um, when you privatized your Facebook page, does that mean that only your allowed friends that are already a part of your Facebook page and family, or whoever you have added on your social media Facebook page, were allowed to communicate with you? Answer, I don't think that's what it meant because I was receiving messages. I think that it meant that only friends can see the post that I was making, but I don't think it impeded, messages because I was getting messages from people I did not know who were not friended. Question, to clarify, you could have private that too. Miss Olson, objection, Your Honor, and move to strike to the extent that the witness or TikToker just testified. Okay. Question by TikToker. Okay, question. You are aware that the court, TikToker, I'm going to sustain the objection and will strike that last statement that you could private that too. The jury is instructed to disregard that. You can re-ask the question and have the witness answer. TikToker, yes, sir. And then TikToker goes on to say, the posts on your social media were only able to be viewed by family and friends and those a part of your Facebook page, correct? Answer, as far as I am aware, that was the steps that I had taken on November 24th, 2022, was to make it so only the friends and family were able to see my post, though I also stopped posting. But I think it's retroactive as well, so mostly I was trying to prevent pictures of my kids being widely available. I was just trying to stop that. Thank you. On your Facebook posts, with the support of your family and friends, your decision to withdraw posting and your work or anything else you would post on Facebook was solely your decision, and it was not based on any threat of being ridiculed or harm. Is that correct? Because your Facebook page was private. Miss Olson, Your Honor, I'm going to object to the form of the question. I think it's compound, and I'm not clear what the question is. The court, I'll sustain the objection. It is a compound question, meaning it's got too many parts, so if you'll just break it up, please. TikToker, if your decision not to post on social media was a decision that you were not going... Hold on. If your decision not to post on social media was a decision that you were not going to post to your close family and friends and those that you allowed to be on your Facebook page, is that correct? What? Okay. Answer, in the initial 6 weeks before the arrest, I essentially withdrew from life. So yes, I was not posting anything even to close family or friends. Question, and that decision was solely your discretion, your decision, and not because posting on your Facebook would cause ridicule from your family and friends. Answer, yes, sorry. I'm thinking about the moving parts of this. So that initial moment, that initial 6 weeks, everything ground to a halt, and I did not want to engage or boast or anything, I was still communicating with family and friends in other ways. I just wasn't creating content or sharing things widely. Moving forward, I never felt that I had the ability to have a public facing set of social media, whether Instagram or Twitter or Facebook, because I couldn't open myself up. It didn't feel safe. So I think there's 2 stages to that question. The initial stage where just everything stopped, and then the ongoing nature of the allegations after the arrest, and how that made it very difficult mentally, emotionally, physically to establish any sort of public-facing social media profile. TikToker, thank you. We already acknowledged that Moscow Police Department made a statement that you were not a suspect December 27th of 2022, correct? Answer, correct. Question, Koberger was arrested end of that year, beginning of the next year, correct? Answer, December 30th, 2022, correct. TikToker states, you had the support of your family, friends, professional career, correct? Professor says, again, you're making a really broad category of humans in professional career. My immediate supervisor was helping me navigate and look at options. My close family and friends who knew who I was absolutely was getting us through this. Question, the reason why I'm why I ask is because you said you didn't feel safe. Why didn't you feel safe? Answer, I will never feel as safe as I did on November 23rd, 2022. That is sad. That is so sad. Question, why? Answer, because you were calling me a murderer and a sexual abuser still after the arrest. And TikToker, I object. Can I object? No, you can't object to your own question. What do you mean you object? You're the one that answered the fucking question. Oh my god. Ma'am, be so serious. No, let the witness answer the question. TikToker, okay. Answer. And I was being made very aware that there are still people who are willing to listen to those lies. I will never be able to have those statements, those false statements, as part of my life. So yes, I continued to feel scared. The anonymity that we had felt prior in our lives is gone. There was a giant spotlight on me as a human, so yes, I felt scared. Oh, TikToker. My objection was, she said that I called her a sexual abuser. That's not true. Gross. Answer, you accused me of having a sexual relationship or a romantic relationship with a student. The policies we reviewed yesterday, that is considered sexual harassment and abuse under U of I policy. So yes, I would say you accused me of abusing someone who would have been inherently under my purview. That's how sexual harassment works. If you're in a power dynamic that you have power over someone like a professor and a student, that is sexual harassment. That's the definition of sexual harassment. So by saying that I did that, you implied that I abused my students. I am so proud of her in this moment because the transcripts from the first day, you can tell that she's just kind of not scared, but you can tell that she's just very caught off guard by how the TikToker is like talking to her and how the TikToker is like being very rude and very like just kind of nasty. And then she still is on the second day. She's just going in on her and saying all these kind of rude things. But I love in this moment where she's like, "No, you did. You called me that, and I'm gonna call you out on it in front of this jury because that's what you did." And I just love it. I love that she was like, "Nope, I'm taking back my power a little bit because screw you." Um, yeah. Question by TikToker. Thank you for clearing that. Thank you for clarifying that. You do acknowledge that my statements regarding your alleged, or that is now considered false relationship with a student was not in any threat to be investigated because your boss, you had the support of your boss. Is that correct? No, it's not. Answer, that's not correct at all. It was investigated by the University of Idaho because the allegations were made. Just because my immediate supervisor was supporting me does not mean the allegations did not carry weight. Question, when was that investigation? And the reason I ask is because I subpoenaed the University of Idaho and they said they did not investigate you. Oh, Lord. Miss Olson, Your Honor, I'm going to object and move to strike. TikToker is testifying again. The court, I'm going to sustain the objection. TikToker, you have to ask the witness just questions based on her personal knowledge, and she has to have foundation to answer it. And you can't testify to things that she may not have knowledge of, so you'll have to rephrase the question, please. TikToker, yes, sir. Question, based on your knowledge, when did the University of Idaho investigate you? Answer, I am not aware of the date range, but I know that the University General Counsel looked into the matter and verified that I did not have any contact with any of the students or Brian Koberger. Question, to your knowledge, when the General Counsel looked into the allegation, was it in response to the subpoena or was it in response to the subpoena? Miss Olson, Your Honor, I'm going to object. Other than the foundational grounds, she's asking what someone else did. That is going into hearsay. The court, I'm going to sustain that objection. I'm going to sustain that objection. TikToker, I don't think this witness knows. You can ask her about what is in her knowledge and purview, not what someone else might have done, and why. Question, Ms. Scofield, Professor Scofield, sorry. In the event that any professor is investigated by their university, are they provided with notice of results or the investigation? Ms. Olsen, objection, Your Honor. This is now just a hypothetical. Objection on the grounds of improper question. TikToker, it's not hypothetical. She said she was investigated. The court, and you can ask her if she was provided notice. If you just had a lawyer, you wouldn't have to. And that's the thing, too. I think with lawyers, like, you can probably hand them a ton of questions and be like, well, I kind of want to get into this, and they can figure out how to answer it properly or ask it properly, but my goodness, woman. Okay. Question. During your investigation, did the University of Idaho notice you that you were going to be investigated and the results of that investigation? Answer. I was never served with notice of investigation, but I do know that one happened. Question. How do you know an investigation happened? Answer. I genuinely don't know. I would assume perhaps through this lawsuit. I'm sorry, I don't know when I was informed. Question, do you have any evidence outside of this testimony to support that you were investigated by the University of Idaho? Answer, I do not have anything physically. I believe we will discuss this later in the trial. Question, okay. Can you clarify that the time you said first that you were not home during the murder of the 4 students? Answer, correct. Question, please clarify again when you got home. Answer, yeah. So my husband John and I, left Portland right around 7 a.m. and we, it's about a 6-hour drive. So we would have been getting back to Moscow. I'm sure we stopped to gas up. I think we probably arrived around 1 p.m. or so. Oh, she's finally done. TikToker, thank you. No further questions. The court, all right, thank you. Miss Olsen, redirect. Miss Olsen, yes, please, Your Honor. And if we could please have the evidence presentation, please switched over to Miss Bibb's computer. Redirect examination by Miss Olsen. Okay. Cool. By Miss Olsen. Question, Professor Scofield, I'm going to start with us going back to exhibit number 34. Ms. Olsen, Your Honor, TikToker was provided with an unredacted copy and confirmed that what is under the redactions, and so, Your Honor, at this time, we would offer, based on the foundation yesterday, exhibit number 34. TikToker, any remaining objection to that? No objections. Court, so we're going back in. They're trying to do exhibit 34. So the court, TikToker, any remaining objection to that? TikToker, no objections. Court, all right. Plaintiff's exhibit number 34 will be admitted and published if you wish. I do not have this because even with the redacted stuff, it's still medical information, so I don't think we can ever get access to this one. Okay. Ms. Olsen, yes, please, Your Honor. And then Ms. Olsen's line of questioning. And Professor Scofield, I think when you testified yesterday, you identified exhibit 34 as also a document that you received from Gritman Medical Center reflecting charges of services related to the physical and mental health treatment that you received after TikToker's false accusations. Is that correct? Answer, that's correct. And there are 2 black boxes, one on the screen and one at sort of the top. And have you confirmed what is under those black boxes? Answer, yet. I confirmed that those black boxes are covering the name of my daughter. Question, and the charges of services rendered to her? Answer, exactly. We're not asking for charges related to my children. Question, and you're not asking for damages for services provided to your children, is that correct? Answer, thank you, yes. Question, okay. And then with respect to exhibit 34, just to orient the jury. Miss Olsen, Miss Bibb, if you would zoom in as you had previously before I asked about the black boxes, and then question. At the very top there, for example, it says Rebecca E. Scofield, Ronald F. Baldwin, MD. Who is Ronald F. Baldwin, MD? Answer, that was my primary care provider at the time. Question, and then on the line below that it says office or other outpatient visit. What is the date of that one? That's February 24th, 2023. And then if we go and read across the exhibit, there are some amounts and, read down the exhibit, and at the very bottom, there's a payment from Rebecca Scofield. Is that correct? Correct. and it reflects $20. Is that your copay again? Answer, that's the standard copay, yes. Is it the same for any other entries on Exhibit 34? They show the provider, the date of the visit, and an amount that you paid. Is that correct? Answer, that's correct. Question, and so if you would turn, I think it's to the second page, and I did not bring my Miss Olson. Is there a third page, Miss Bibb? Question. If you go to the very bottom of the second page, it has in there a visit of March 26, 2024. Correct. Answer, correct. Answer, and is that then the date range of this exhibit, the one we saw at the beginning, which was for February of 2023 to the end there in March of 2024? Answer, yes, that's correct. Question, and there are different visits from those we looked at yesterday in Exhibit 32. Is that correct? Answer, yes. We confirmed that there are no overlapping visits. Question, Professor Scofield, I next want to turn to what are truly the redacted questions, or redirect questions, sorry. And I'm going to ask Ms. Bibb to pull up Exhibit 519, the GoFundMe page that TikToker went over with you. Do you see that? Answer, I do. Question, now on this GoFundMe page, you didn't operate it, correct? Correct. What responsibility did you have for any of the content on the GoFundMe page? Answer, our friend asked if it was okay to do this for us, and we said yes. Question, did you input court, Miss Olson, do you want that published? Or Miss Olson, yes, please, sorry, thank you, Your Honor. I think it's already in evidence. Court, it is. Question, back to Miss Olson. And so, Miss Scofield, or Professor Scofield, my question is, there's type on this page, correct? Correct. Sorry, it's like type. What responsibility, if any, do you have for the words that were input on the GoFundMe page? Oh, okay, that makes more sense. My friend wrote them, she put them in, we weren't responsible. You didn't write them. I did not personally write them. I take it you were generally in communication with this friend. Yes. You were generally aware of what she was doing. Yes. The exhibit that TikToker put up for you, Exhibit 519, this is an update from July of 2024. Correct. Correct. And in the first paragraph there, would you please read that aloud? Answer. In June, the judge granted the motion for partial summary judgment, ruling the defendant has defamed Dr. Scofield and granted the motion to add punitive damages. As requested, damages will be determined by a jury in a damages court or damages trial, which we hope will be scheduled soon. And that was posted in July 2024, correct? Correct. And it said by then, $22,741 had been raised, correct? Correct. And was all of that money used to pay your legal fees in this case? Yes. The legal fees that had been incurred up to that time? Yes. Since July of 2024, has TikToker continued to file pleadings in this case? Yes. Has she continued to contest the decisions rendered by the court in this case? Yes. And have your counsel respond to those? Yes. And has that incurred over the last year and a half since this update? Yes. And have there been any more legal fees raised through this GoFundMe page? No. Miss Olson, please take that down, Miss Bibb. Question, Professor Scofield. TikToker asked you a series of questions about whether you had the support of your spouse. You remember those questions? Yes. And she asked you if you were concerned about not having the support of people like your spouse and your friends and things like that. Answer, yes. Were you concerned about the reactions, whether it was termed support or anything else of people outside of that group of people, outside your friends, your family members, and the dean of your school? Absolutely are. And why were you concerned about that? Our fear from the beginning was that those people didn't know me. They couldn't judge whether what she was saying could possibly be false or true, and that someone could believe her and take justice into their own hands, or the person who had committed these murders would take interest in our family and target us. It was that this was in front of millions of people who had no standard to judge me by, and therefore associate just my name and face with these lies. And that's the thing that really got me. And I've probably said this too earlier on in one of the streams. I really wish that And I mean, neither here nor there, and she's free to do whatever she wants. They're both grown adults. But the fact of the matter is that a lot of people who feel a very big type of way will try to take justice into their own hands if they feel like justice wasn't provided. So the fact of the matter is, like, Koberger was arrested on December 30th, but all of this started up in like late November. So they have a month of people who are can go insane or feel like they need to do something, and they will hop on a plane and go. They don't care. And that's what I think is the craziest part of this, is that when you are on social media or when you're on social media or on YouTube or TikTok, especially TikTok or YouTube Shorts, those go very fast and they can spread like crazy, especially on Instagram and all of that stuff. And the fact of the matter is, when you know, you know that it can go that far and it can go that fast, and you continuously put her name out and all of this crazy stuff, and you don't care that someone could get hurt because of your words. And I think that that is the main thing that really frustrates me. Is like, everybody, like, growing up, you're like always trying to be like, well, sticks and stones may break my bones, but words will never hurt me. It's like, no, words will, because they'll incite violence. So it's just this craziness that I mean, granted, it's, to me it's infallible. I don't understand why you would sit there and you would just spew nonsense for no reason. But I think I've said in one of my videos too, like, I'm not going to go on to Al Gore's internet with my cards and accuse someone of murder, because there's just no reason for that. But I think what we don't realize in a society that's built recently on social media, and I'm not I'm older. I'm 30. So I grew up without a lot of social media. Like, I grew up with a freaking computer down in my basement where if I had to call on the landline, I couldn't be on the computer, you know? So for me, I didn't really care about what was on social media or anything of that nature as I got older. And like, now that I'm in, like my 20s, I cared. I'm 30 now. I don't really care again. But for me, I think what happens, and I again, I can't speak for the TikToker, I can't speak for anybody that I don't know, but for me, I think what happens is that we get so drawn in because we want the validation. And especially from the older generation, like the older generations, some of them really want that validation. And I think they kind of go to the extreme where other people, they're like, it's nice, but I don't care. Like, I have people who support me, I have people who care about me, and that's all the validation that I need. But I think it's this weird ball game that some people play on social media. Again, can't speak for everybody, but I feel like that's one of the bigger things that I've noticed now in the sphere, is like, people chase that dopamine of like wanting to feel important or wanting to feel some type of way, where they don't realize the harm that they're doing to others. And it kind of sucks. Like, recently there's a case that I've seen. It's from this streamer, and he like OD'd at one point and stuff, and messed up his face. He was, apparently it's called look maxing. I don't know. Anyway, I know we're supposed to be talking about transcripts. I'm so sorry. But like, it's him. He like chases that, and he chases all that stuff, and now he's in lawsuits and stuff, which is wild to me. If you want me to cover that, I will definitely look into the lawsuits and stuff. But it's just kind of heartbreaking because I think he's pretty young. I want to say he's in his like early 20s. But it's just like he's just chasing that validation because that's all he's known. And it kind of breaks my heart when I see that. But yeah, the fact that she just can't let it go, and she just couldn't be like, oh, my bad, I'm sorry. Like, they found the killer. Oopsie, you know. But again, it's that, like, well, if I retract that statement, then I'm going to get all the hate. Um, empty profile said, with no context or additional information, I feel like she's doubling down because she feels like it would void her spiritual journey. Maybe, but so I was in the Navy, for those who don't know. And a lot of people in the Navy go through that. They go through like the spiritual journey or the witchcraft or like whatever, and they find their home in like those little pockets. Like I knew a guy who was deeply spiritual and he had like a mini altar in his rack and stuff of that nature. And one thing that I learned, like with talking with all my friends and stuff about that, is like no one will discredit your spiritual journey unless you let them. And I think that's what the biggest thing is like if you let them, then they will. And I think with her, it might be that where she might have accidentally let them. Or she might think in her head, if I'm wrong, then they're going to discredit everything. Which in reality, it's only if you let them. So, okay, tangent over. Back to the transcripts. I'm sorry. Sorry. Okay, so question by Ms. Olson. Professor Scofield, in your upbringing, in your career, did you strike to gain recognition or popularity from being accused of orchestrating the murders of the 4 University of Idaho students? Answer, I did not. Question, did you strike in your upbringing or strive in your upbringing or in your career to gain recognition or popularity from being accused of having a sexual relationship with one of the students? Answer, I did not. Miss Olson, thank you, Professor Scofield. The court. TikToker, I don't typically allow recross, but because we have this issue with exhibit number 34, that would have come in yesterday. If you have any questions, just as it relates to plaintiff's exhibit number 34, you may ask him. If not, I will excuse Miss Scofield as a witness. And then she wants to do recross. So, question, Professor Scofield, did your treatment begin from exhibit number 34's treatment records? Is that correct? Correct. When did you begin treatment at the facility? So as we went over in testimony yesterday, I began having symptoms in December. They worsened in January. I called in January to set up that February 2023 appointment. So treatment began in February of 2023 and is ongoing. Question, before February 2023, I just want to clarify, you had no affiliation with that doctor or clinic hospital. Answer, no. The physicians listed were already my primary care providers. Gritman was already my hospital. I had never been seen for those symptoms previously. This started a whole new treatment for new physical issues. Answer, please clarify the physical issues. Answer, as stated yesterday, these included headaches, nerve compression, hip pain, shoulder pain. Yeah. Question, beginning February 2023, correct? Answer, the pain started in December of 2022. I was able to get an appointment in Moscow, Idaho in February of 2023. Question, after your hysterectomy? Yes, completely unrelated to the hysterectomy, which I had been cleared previously by my OBGYN for having. Question, thank you. Professor Scofield, do you have a professional who diagnosed you with headaches? You said headaches and nerve pain, nerve damage, and answer, nerve compression. Answer, nerve compression, yes. Answer, yes. And did that professional connect the nerve compression to the TikTok videos? Answer. So in my physical therapy, routinely those accusations and the strain, emotional and mental that came from them was noted throughout my physical therapy. Question, your diagnosis. Can you share the name of the doctor who diagnosed you, or it's just general primary care from Gritman? I don't see how that... Oh, she's asking if she saw a specialist. Oh, okay. Answer, correct. I'm also confused on the uses of the term diagnose in terms of these are symptoms. Having severe and persistent headaches, having nerve compression, those are symptoms. I can't say what a diagnosis is, though. Certainly, I have been seen by many doctors about these issues routinely over the last 3 years. The court, in TikToker, if you'll just confine your questions to plaintiff's exhibit number 34. We've been through much of this yesterday. TikToker, yes, sir. Court, thank you. And then back to the questioning. Regarding exhibit number 34, those treatment records are, you don't have a diagnosis from those. It's only symptoms, correct? Girl, he just said not to do that. Miss Olson, Your Honor, object. Exhibit 34 is payment records from visits. TikToker that she intends to connect to damages from mental health. The court and TikToker, you've cross-examined on that point yesterday. All I'm allowing you to do today is to ask questions that you might have about the Exhibit 34 itself. And then back to questioning. Okay. So that would mean that your payment records or your treatment records in exhibit number 34 are all payment receipts. Answer: these include all payment receipts. Question: those are from nerve damage, headaches without a diagnosis. Correct. Miss Olson, objection, Your Honor, beyond the scope. TikToker, I just want to, the court, I'll allow that last question. He was so kind to her to allow her to do this stuff, because if this was an actual lawyer, he would have torn that lawyer to shreds. Yeah. Answer: I'm much of the last 3 years have been about addressing these issues. I don't want to use the word diagnose because I don't know the technical aspects behind that. However, every time I go in and they ask what's occurring, we go over the same issues and attempt to ameliorate them. I probably said that wrong. My dyslexia is kicking in. I'm like, so I'm sorry, I don't know. I don't know the answer to the question about diagnosis. The court, anything more? TikToker, it wasn't about diagnosis. The court, anything more about Exhibit 34, TikToker? TikToker, yes, she didn't answer my question. I was not asking about diagnosis. I was limited to only asking if those receipts in Exhibit 34 were all for the nerve compression and headaches. Answer: yes, yes. When I reviewed these were for headaches, things associated with headaches like dizziness, nerve, leg pain, nerve compression, neuropathy, those sorts of, we went through and confirmed that these are appointments to address those ongoing issues. Yes, TikToker, that's all. Thank you. The court. All right. Thank you, TikToker. Ms. Olson, may Professor Scofield step down and be excused as a witness? Yeah, which is insane when you think about, my understanding is that pro se defendants should be held on the same standard as an attorney, which is not encouraged. Yeah, pro se defendants are supposed to be held to an attorney standard, but courts give them more grace because they don't want to be caught in doing something that could possibly overturn their decision. So a lot of times they'll get more grace than the average attorney will. Excuse me. Can she step down and be excused? Miss Olson, yes, please, Your Honor. The court, ladies and gentlemen, I think this is also a good time for us to take maybe a 5-minute comfort break, get a drink, use the restroom. So we'll take about 5 minutes, 5-minute recess. The jury will be excused. They're exited out of the courtroom. The court, Professor Scofield, may step down. All right, the court will be in a brief recess. We'll return at 10. The following takes place outside the presence of the jury. The court. All right, please be seated. Miss Olson, it's your intention to next call TikToker as a witness in your case in chief. Miss Olson, yes, Your Honor. The court. All right. Then under Federal Rule of Evidence 611, you'll be permitted to treat her as an adverse witness because she's the adverse party in this case, which means, TikToker, that she will be able to ask you leading questions, as if this was a cross-examination. When she's completed her direct examination, then, as we discussed, you'll be able to ask yourself questions and answer those questions. You can ask those questions in any form that you wish to ask them, whether non-leading, who, what, why, where, or when, or leading, isn't it true that, and then whatever the question is. So, however you wish to ask those questions, you may, and then wait before answering. Miss Olson will have the opportunity to object if she wishes. If not, you just go ahead and answer the question. Does that make sense? TikToker, yes, sir. May I also bring paper and pen? Because I'll have to take notes on what's being asked of me as a witness so that I can cross-examine myself. The court, yes, you may. Any objection to that, Miss Olson? Miss Olson, no, Your Honor, as long as it's clear that whatever paper she has up there doesn't have any notes going in. The court, it has to be a blank pad, and then you can take whatever notes you wish. TikToker, yes, sir. The court, all right. Are we ready for the jury? Miss Olson, yes, Your Honor. The court, Mr. Gordon. The jury enters the courtroom. The court, please be seated. All right, members of the jury, we're on to our next witness in the plaintiff's case in chief. Plaintiff intends to call as their next witness the defendant, TikToker. This is permitted by the rules, under the rules, because TikToker is an adverse party or the party on the opposite side of the plaintiff. Plaintiff's counsel is able to examine her as an adverse witness, meaning she can ask her leading questions on direct examination. Questions that suggest the answer in the question. Isn't it true that? And then the question. Then once Attorney Olson has completed her direct examination, TikToker will be able to cross-examine herself. It may seem a little unnatural, but it is not unusual at all. It's common in this type of case where there is a pro se party for that party to ask themselves a question, pause to allow for an objection, and then answer the question. So that's how we'll go through the examination of this witness. Miss Olson, if you'll call your next witness. Miss Olson, thank you, Your Honor. Plaintiff calls TikToker. Okay, so they swear in TikToker. The court, TikToker, if you'll take the witness stand, you may be seated. Thank you. Miss Olson, you may inquire. Oh, I'm sorry, if we'll ask the witness her name. The courtroom deputy, can you please state your full name and spell your last name for the record? Yes, it's TikToker, or I don't care. The court, now you may inquire. Thank you, Your Honor. And then direct examination. TikToker, you have never met Rebecca Scofield until Monday morning, is that correct? Answer, yes. You've never met her husband? Yes. Or her children? Yes. You have never been to Moscow, Idaho, correct? Correct. Or to Idaho at all before attending this trial, correct? Correct. You've been living in Thailand the last 5 months since about early October, correct? Answer, traveling, living, if that's the same, yes. Well, that's where you have an apartment, correct? Yes. And we're traveling throughout Thailand, correct? Yes. And went to beaches, yes. You went to an ocean or a sea, I believe a sea. And you went out to dinners, yes. You went shopping, yes. And that was the cumulative of a number of months of travel in Europe and Thailand, the Dominican Republic. Is that right? Throughout the years, yes. And prior to that, you were living in Houston, Texas, correct? Louisiana, and you were living in Louisiana before you moved to Thailand. Temporarily, yes. And before that, Houston, correct? Yes. And Houston is where you were living when you posted the TikToks falsely accusing Professor Scofield of ordering the murders of the 4 University of Idaho students, correct? Yes. Or correct. And Houston is where you were living when you posted the TikToks falsely stating that Professor Scofield had an affair or a relationship with one of the murdered female students, correct? Yes. And I think you mentioned you have traveled over the years. In 2025, you had 8 passport stamps, correct? Yes. Went to the UK, France, Italy, Dominican Republic, Japan, Thailand, Vietnam, and back to Thailand. Good God, woman. Hold on. 1, 2, yeah, 8. 1, 2, 3. Jesus. Ugh. You came back to the United States less than a week ago for this trial, right? Yes. TikTok, are you familiar with the social media platform TikTok, correct? Yes. And you know how it works, correct? Yes. TikTok is an application you can download to an electronic device to make short video clips, correct? Yes. And the device most commonly used is a cell phone, correct? Yes. TikToks are usually short video clips, correct? Correct. And you can set the app for how long you want the video to be, correct? Maybe a few seconds up to 10 minutes now. 10 minutes is a long ass time on a TikTok. Holy crap. You might as well just make a long form video at that point. And that's what the user can do with that app, correct? Yes. You can make that choice. Yes. It has a timer for hands-free filming. Yes. Add music, add text, add photos or videos. You can edit sound effects. You can add a description. Yes. Hashtags. Oh, you can add hashtags. Are you asking on my abilities to do things or just anyone's ability to post on this app? I said, well, a person can do that, correct? Jesus. I don't think fighting an attorney is probably the smartest way to start your direct examination, but a person can add hashtags, correct? Correct. And a hashtag is a clickable keyword that characterizes content to improve things like discoverability and searchability, correct? It's for subject-based marketing or categorizing. And so if someone is looking for content on a particular topic, they can use a hashtag to find that topic, correct? Correct. And if you're posting on TikTok, you can use a hashtag so that people who are interested in that content can find your TikTok, correct? Correct. And you knew how to do all of these things on TikTok by November of 2022, is that correct? Clarify all. I knew. May I clarify what I knew how to do? I'll ask the questions, TikToker. Dang. So you knew how to do hands-free filming, correct? You knew how to set the timer for how long you wanted the video to be, correct? You knew how to add music, you knew how to add text. You knew how to add in other photos or videos, correct? More like a photo too. Yes, I'm not sure how to add another video. You knew how to edit sound effects, hashtags. You knew how to tag people. And that's something you knew how to do, correct? And you knew how to post a TikTok so people could see it. Yes, and TikTok pays a certain amount to content posters per 1,000 views, correct? False. It's your assertion that TikTok doesn't pay for people who post, correct? They do not pay for people who post. Okay, that's not true. TikTok does pay out people. TikToker, you've recorded your own YouTube videos, correct? And you've appeared on other social media hosts' YouTube channels, correct? Correct. You have an Instagram account, yes. You've posted on Instagram account regarding your travels, correct? And yes, and you've posted on that Instagram account regarding purchases and places you've been on your travels, is that correct? Yes. TikToker, in 2022, you promoted yourself online as someone who could solve mysterious deaths, correct? Correct. That is something you told online users through your various social media accounts, correct? And one of those unsolved murders that came to your attention was the murders of the 4 University of Idaho undergrad students on November 13th of 2022 in Moscow, Idaho, correct? Define came to my attention. You learned about it? Someone asked me to post about it. I didn't know about it at the time. Question, well, that wasn't my question, TikToker. You learned about those murders, correct? No. Are you speaking of initially where it came from? No. I'm just asking if you learned about the murders that occurred in Moscow, Idaho on November 13th of 2022. On November 13th of 2022, I did not know or learn about the murders. That wasn't my question. Jeez. So, TikToker, you would agree that you learned about murders in Moscow, Idaho of 4 University of Idaho students, and that those murders had occurred on November 13th of 2022. You learned those facts, correct? Correct. And you were in Houston at the time, Louisiana, and then you went back to Houston. Yes. In the first few days after the murders, you became aware that no suspect had been caught, correct? I don't know what a few days means. I didn't learn about the murders until around November 24th, 2022. And yes, I learned that no suspect had been caught. You learned about the murders certainly by November 23rd, 2022, because that's when you first started posting about them, correct? Sorry, November 2023. November 23rd. Jeez. And then you learned then that no suspect had been identified. Is that correct? Correct. You became aware of a lot of online speculation about who the killer could be, correct? Correct. And why the murders were committed, correct? Correct. In the online speculation about who the murderer was, you didn't learn anything about why the murders may have been committed. There was no speculation about that you recall. No. Well, it may have been speculation, but I wasn't I wasn't a part of it. I'm not asking if you were a part of it. I'm asking if you had learned that there was speculation about the reasons for the murders. Answer, no. Question, on November 23rd of 2022, you began posting on TikTok about the murders, correct? Correct. And by November 24th, you began posting on TikTok that Rebecca Scofield had orchestrated the murders, correct? That sounds correct. And that she did so because she was having an affair with one of the female murdered students, correct? Correct. How many TikToks had you posted stating that Rebecca Scofield observed or orchestrated the murders? Maybe 5 or 6. No, 115. How many TikToks have you posted stating that Rebecca Scofield was having an affair with one of the murdered female students? Maybe 4. You posted additional TikToks making those allegations the next day, November 24th, correct? Sorry, the same day, November 24th, correct? And you posted more on November the 25th, correct? Well, when I said 6, I meant total. I don't know about that specific day. I can check, though. You didn't check before your testimony here today? Oh, no. And your TikTok account has been taken down, correct? Yes. And you used hashtags so that people searching for online content about the murders would find your TikToks, correct? Correct. Miss Olson. Miss Bibb, if you can bring up exhibit number 40, which has been admitted into evidence. And then question, TikToker, exhibit 40. That is one of the TikToks that you posted, correct? Correct. And we watched it in court yesterday, correct? I believe you. I don't remember, but correct. How do you not remember what happened yesterday? Okay. It includes the professor, or includes a photo of the professor, correct? Correct. And you obtained that photo, correct? Off of the University of Idaho website, yes. Yeah, and it was the photo of Professor Scofield, her official photo on the website, correct? Correct. And you were able to track down the University of Idaho website, correct? Correct. And you were able to track down the photos of the faculty members, correct? Yes. And you were able to find Scofield's photo, correct? I wasn't looking for her photo, but it was there. It was on there, correct? You were able to find her photo, correct? Find would imply that I was looking for it. I saw her photo on the website, correct? And you found it there. Yes. And you included on this a photo of her faculty, or excuse me, the content of her faculty biography, correct? Yes. And you have obtained that from the University of Idaho website. Yes. You tracked that information down and put it in your TikTok. Yes, yes. And that's you in the TikTok, correct? Correct. Ms. Bibb, would you please play exhibit number 40, plays video? And I think this is the video from November 24th of her, like, stepping away and showing a full photo of the professor and saying that she's the one that committed the murders. Question. And Miss and TikToker, I'd next direct your attention to exhibit 41, which has not been admitted. So, Miss Bibb, will you pull up just the initial screen there? And TikToker, from looking at this initial screen of exhibit 41, do you recognize this as one of the TikToks that you posted? It looks like one of the ones I posted. You had the opportunity to, and you did review exhibit 41 prior to trial, correct? Were you able to tell that it is a TikTok video that includes you and you're talking about Professor Scofield, correct? I did not bring my notes to stipulation as to whether this specific exhibit was authentic, but I did email you, so if I emailed you and said it was authentic, then yes. She is trying so hard to remove herself. TikToker, I don't want you to be guessing up there, so I'm going to ask, I don't know if we want to hand this to Mr. Gordon or the court. Yes. Would it help you to look at the email that you sent where you agreed to the authenticity of the exhibits? Yes, thank you. The court. And for the record, TikToker, if you could just describe the date and the to and from of that email. Oh, nope. Hold on. Oop, hold on. Nope. That has her stuff on it. Oopsie. I thought I got... My apologies. I genuinely thought that I had... Apologies. I genuinely thought I took out this email, and apparently I did not. So, my bad, folks. I just don't want her email out there. No offense, but I know she gets a lot of hate, and I'm trying to prevent that as much as possible, because at the end of the day, like, it is what it is, but I also just don't deem it necessary for that. So, apologies. The witness, this email was dated February 24th of 2026, 2:03 a.m. from TikToker to all of the attorneys. It's titled Defendant's Response to Plaintiff's Amended Exhibit List. Question, TikToker, could you please take a look at that and see if it refreshes your recollection as to whether Exhibit 41 is the one that you stipulated as to authenticity? Yes. And is it correct? Yes. And so Exhibit 41 is one of the TikToks that you made and posted, correct? Correct. Also on November 24th, 2022, correct? I don't know, but it looks to be that date based on the couch. Your Honor, at this time I'd offer Exhibit 41. Any objection? No objection. And will be admitted and published if you wish. Yes, we would request permission to play it for the jury. The court, you may, playing the video. All right. And TikToker, that's the entire TikTok that you posted, correct? And it appears to be from the same day because it's you in the same, I think, shirt, and it's the same picture of the professor that we looked at in Exhibit 40. Is that correct? Yes. And Miss Bibb, if you please go to the initial screen of Exhibit number 41. And there are some words that appear on the initial screen, correct? Correct. What did they say? Rebecca Scofield ordered the murder of Kaylee and Madison at the University of Idaho students. And you put that type on the initial screen of your TikTok. Is that correct? That's correct. And you decided what to say. That's correct. All right, that was Exhibit number 41. TikToker, I'd like to next direct your attention to Exhibit number 1. And if you'd look at the screen in front of you, Exhibit 1 is a TikTok that you posted on November 25th, 2022. Is that right? I believe you. Well, you have it in front of you again, the document that we looked at earlier, to refresh your recollection. Is that correct? I don't object to the authenticity. I just can't confirm that it was November 26th because I don't know. You don't remember the dates you posted on these, is that right? Yes, and I don't put the dates on my notes in your email. Ms. Olson, Your Honor, at this time I'd offer Exhibit number 1. Any objection? No objection. It will be published for the jury. Yes, please, Your Honor. And Ms. Bibbs, will you please play Exhibit number 1? And TikToker, that's your voice in the TikTok, correct? Correct. And this policy that we see here, the B policy, that's the same policy that we looked at yesterday in Exhibit 25. Is that correct? Yes. And you chose to put this policy in your TikTok, correct? Correct. And you found it online. Is that right? Yes. And you say that she was worried about losing respect, correct? Correct. And you would agree that would be a natural outcome if someone was accused of having an affair with a female student, correct? Pertaining to this, no, that was not my intention regarding this video. I was saying she would lose respect for actually being caught having a relationship with a student at that time, is what I believe. It wasn't about speculation or false statements at the time. Well, you knew at the time that a consequence of the allegation you were making, that Professor Scofield risked being punished according to that policy, correct? False. TikToker, I'm next going to direct your attention to Exhibit number 2. You recalled watching Exhibit number 2 prior to trial, correct? This is the TikTok you posted on the 26th. It includes your voice. It's about 10 seconds long, I believe so. Your Honor, at this time I'd offer Exhibit 2. Any objection? No objection. It's admitted. Plays video. TikToker, this one also has type on the initial screen. Is that correct? Yes. What does it say? The 2 people who partnered to kill the 4 University of Idaho students, Rebecca Scofield and Jack DeCoeur. If you don't know who Jack is, he was an ex-boyfriend of one of the victims. So I'll probably just call him ex-boyfriend at this time because this poor guy he's already going through a lot. And in this, well, first you chose what words to put on the screen for Exhibit 2. Is that correct? Yes. And you referred to the young man. Yes. And you never met him. No. Or you never met him, correct? Correct. And you later learned from a subpoena you sent to the University of Idaho that the professor never had any communications with this man, correct? The subpoena stated that there was no proof on investigation that she had communications with him. I'm not sure if it's the same as what you just said. Well, you obtained no evidence whatsoever that the professor had any communications with a person named that, correct? Yes. And you certainly didn't have any evidence or facts at the time that you made the statement, correct? Correct. All right. If we could next look at Exhibit number 3. Do you recognize Exhibit number 3? Correct. And that is also the TikTok you made and posted about Professor and the murders of the University of Idaho, correct? You watched this prior to trial, correct? It's a TikTok you posted on the 20th of 2022. Again, I'm not sure of the dates, but possibly that's correct. It includes your voice, it includes you, and it's 59 seconds long. Your Honor, at this time, I'd offer exhibit number 3. No objection. They admit it and publish it, and then they play the video. And TikToker, with respect to exhibit number 3, that also has some type on the front. Is that correct? Yes, and that's type that you chose to put in the TikTok. Correct. And would you please read that type? I don't care what y'all say. They killed the students. Please keep reading. Sorry, I'm not sorry. Give me a minute. Rebecca was the one, I'm sorry, to initiate the plan. Sorry, just one moment. Court, take your time, and hired the guy. And when you did you need to take a break? TikToker, just one moment, please. Thank you. And TikToker, when you made this TikTok that we see in exhibit number 3, you still never met the ex-boyfriend, correct? Correct. And you didn't have any facts that showed any connection between the ex-boyfriend and the professor, correct? I would next direct your attention to exhibit number 4. And TikToker, looking at the screen at exhibit number 4, do you recognize the person depicted on the screen of exhibit number 4? Yes. Is that you? Yes. And there's some type on the screen. Yes. And is the type you included on TikTok that has you in it, correct? And this TikTok in exhibit number 4 is also addresses your statements about the professor and one of the victims were involved, correct? I'm not sure. You watched exhibit 4 prior to trial. Yes. And you watched that all the way through, correct? And it's about 2 minutes and 35 seconds long, correct? That would be correct. Yeah. And all of that 2 minutes and 35 seconds is you talking, correct? I love how now that her videos are being shown and like she's kind of like forced to reckon with them, she's like, well, I don't remember and I don't know and maybe. And I'm like, no, ma'am, you know, because you talked about it extensively and you were still talking about it extensively from what I can tell. And I don't know if she's still going on about it, but I know she made like 35 or 36 different parts for this, like from this trial alone. And this trial was only like 4 days. So, yeah. And all of that is you talking about the relationship between the professor and a student, correct? It appears to be. Well, you watched it prior to trial, right? Right. And is that your recollection of it? My recollection of it, I watched 50 documents and exhibits. Sorry, I have no, other than my notes, which states that it appears to be edited and manipulated. That's all I have. I'm sorry. Excuse me. What? It appears to be edited and manipulated? Ma'am. I bet you, mind you. And this could just be like, I bet you, I could probably go. Honestly, I might just ask Atozy and see if he has them. But I bet you there are people who downloaded your videos as soon as you posted them and kept them. The internet is forever. So whether you think you deleted them or not, they're not gone. And I bet you somebody has it and it's not unedited. It's like, and that's what I find so silly. She's like, well, it looks edited. It looks manipulated. No, ma'am. You just don't want to admit the fact that you said some very unhinged things and you don't know what to do with yourself. So you're probably just like, hey, I'm going to say it's unedited or it's edited and manipulated because I don't want to admit to this. Again, speculation. I don't know, but I don't believe that I don't believe that they were edited and manipulated, especially if they were going to do a lawsuit. I don't believe that for a second, especially not for a lawyer. I'm sorry. Lawyers are kind of shady, but I don't think in this instance they would have edited your TikToks at all. I'm pretty sure they would have just pulled them. And I mean, her friend might have pulled them too, like just downloaded them as they went. I don't know. Anyway, dang it. I don't think they're edited. I'm sorry. Okay. Sorry. I just, what? Well, you're not disputing what you watched, exhibit number 4, that it was you in the video, correct? Correct. And you're the one talking in the video. Correct? Correct. And it reflects statements that you made. Correct? No, it reflects words that I said, but it appears to be edited to omit some things and put things, make a sentence that wasn't stated. For example, it's edited. It appears to be edited, manipulated. Okay, then where's your original video? If you think it's edited, where's your original video? Because you can save those from TikTok. Like once you film them, they save into your drafts. So, or they save into your camera roll. So, where's your proof? Are the statements that are made in there are those statements that you made about professor and one of the students? I believe the statements are like a statement from one moment, and then maybe I'm talking about another sentence and a couple of words out of that sentence. It doesn't appear to be a coherent video that I made. And the portions that are in it, they show what you actually said, correct? No, it states a manipulated version of the words that I said in one video. It's not, it's manipulated and edited. And you're saying that based on your recollection, is that right? Yes. And you don't have copies of your TikToks, correct? Yes, I do. You do have copies of your TikToks. I believe I have copies of them. Did you compare exhibit number 4 with the same TikTok that you made? I did not. What the hell? Oh my god. Miss Olson, Your Honor, at this time I'd offer exhibit number 4, the court any objection. TikToker, I do object to the authenticity on the grounds that it's edited and manipulated, but I can look at it. The court, do we need to have a break for you to do that before, outside the presence of the jury? TikToker, I can check my phone files to see if I have a comparison video, but it does appear to be an edited video, and yes, I don't mind taking a break to check. Oh, the court. All right, members of the jury will take a brief recess so we can resolve any authenticity issue on this particular exhibit. We'll be in brief recess for the jury. The court, please be seated. May I go get my phone? The court, yes, you may step down and go to the defendant's table. So, Miss Olson, is TikToker, you can go to the defense table in front of here. Yes, please. As she's heading back to the defense table, do I understand that this particular TikTok, the number 4, dated November 28th, 2022, is an exhibited version of a longer TikTok? Not to my understanding, Your Honor. This is the version that was downloaded. We used a service Page Vault to download from the internet. And just so the court, in full candor, if she can't authenticate it, Mr. Hansen, who also downloaded videos from the internet, could also authenticate it. See, and that's what I thought. I was like, her friend's a tech guy. I bet you, because he was following it, he probably downloaded the videos too. So, yeah. Ma'am, you're not running away from what you said. As much as you wish you could, you're not. All right, and do we want to play that for you, TikToker, right now so that you can authenticate it, or authenticate that? TikToker, yes, please. The court, it is actually you, and you said those words at some point, even if this is an edited version. If you have another version of it, you're free to play that version. But this is a version that Miss Olson has stated was taken off the internet, both by a company they hired and by another witness in this case. And that is the version that they pulled off the internet. Unless you're disputing in some way that this is not you or you did not say those words, I'm inclined to say that it's an authentic video of you that can be admitted at this trial. Miss Bibb, if you'll play that for the TikToker, playing video, TikToker, no objection. The court, all right, thank you. If you'll resume in the witness box, please bring the jury back in. All right, please be seated. Ms. Olson, you can resume your examination. Thank you, Your Honor. TikToker, you now do not object to number 4. Is that correct? Correct. Your Honor, at this time, I'd offer exhibit number 4 and to ask to publish it to the jury. It'll be admitted and published to jury. TikToker, before Miss Bibb starts the video, there's words on the screen, correct? Correct. And those words on the screen are your words, correct? Correct. What did they say? A look into professor and victim's connection. Would you please play exhibit number 4? We would Next, pull up exhibit number 5. In TikToker, you had an opportunity to watch exhibit number 5 prior to trial. Yes. Do you recognize exhibit number 5 as a TikTok that you posted or made and posted on December 1st? That sounds accurate. It is definitely one you made and posted, correct? Correct. And you would agree that around December 1st, 2022 is the correct date, right? Yes. It includes your voice? Yes. Your Honor, at this time, no objections. The publish. Thank you. Before we play it, would you please read aloud the words on the screen? Oh, professor isn't remorseful for ordering the murder of the 4 University of Idaho students. And those are words that you chose to put on the screen, correct? Correct. Miss Bibley, please now play. They played the video. And TikToker, at the time that you made and posted exhibit number 5, you never met the professor, correct? Correct. Never spoken with her, correct? Next, I'm going to direct your attention to exhibit 42. And TikToker, do you recognize the first screen of exhibit 42? Yes. You watched this prior to trial? Yes. This is the TikTok that you posted on or around December 1st? Yes. It includes you and your voice? Yes. Your Honor, at this time, I'd offer up exhibit. Any objection? No objection. All right. It was published. Yes, please. And would you bring that up and just pause for a minute? TikToker, in the upper left corner, there's a little circle and it says reply to Ashley Taylor Lie's comment. And there's a comment there, correct? Correct. And the person was responding and making comments on various posts of that, right? Yes. You knew that your content was reaching many people, correct? Correct. And you also chose the type that is on the first screen of the exhibit number 42, correct? The top left corner, no, the below that in the little box, the rectangle below that, yes. You decided what to put in that TikTok, yes. And what does it say? Professor will spend her life in prison. Would you please play exhibit number 42? TikToker, I'd next direct your attention to number 6. Did you watch this prior to trial? Was this posted? Is that your picture? Is that your voice and the type that you chose? No objection. Read aloud the text. So she's probably just going to go through every video. Rebecca, or professor, is going to prison for the murder of the 4 University of Idaho students, whether you like it or not. Play exhibit. Exhibit number 8. Any objections? No. What words did you choose? Professor and victim's relationship. Plays the video. Is that all you? Yes. Any objection? No. Submit to the jury. What does it say? The professor's relationship with victim, part 2. They play the video. TikToker, these videos that we just looked at in exhibit 7 and 8, where there was a 2-part video posted the same day, that was common for you, correct? You would post a number of videos about the case on the same day, correct? Correct. And you would post a number of videos in a row that dealt with your allegations that the professor orchestrated their murder, correct? Correct. And you would post a number of videos in a row with your allegations that professor was having a relationship with that one murdered student, correct? Correct. And in fact, you posted 15 TikToks on November 24th, 2022, correct? I did not count the amount of videos that I posted. Does that sound about right? It could be. Oh, man. And you have posted 7 on November 25th, 2022, correct? On November 25th, I posted just 7 videos, 7 TikToks about this case, correct? It's possible. Okay. And November 26th, you posted 5 about the U of I murders and professor's role in them, correct? Possible, yeah. And on November 28th, you posted 10. And this is what I mean. It was 115. I forget what exhibit it was exactly, but it was like that showed all of them. Like when we get into her testimony, like where they flip on to the defendant, which is the TikToker, and she takes herself to the stand. she will go through, I think it's like the first few pages, and talk about all the TikToks. And she's like, false, this is not about her. Yes, this is about her. But the underlining theme, I believe, is that she was always talking about the murders, always talking about the professor in some of them, and using the professor's name in the hashtags. And I think that was the main underlining thing that they were talking about. But it's just wild to me. Absolute wild to me. Posted 10 TikToks about that. On November 28th, I posted about the murders, question mark. That's two separate questions. I've posted videos about the murders, correct? I don't know how many of those videos were about the professor, TikToker. The videos we looked at so far in these exhibits were all posted on or before December 10th of 2022, correct? Correct. And they were all posted by you, correct? Correct. I'm next going to have you take a look at exhibit number 9. And the professor, exhibit 9, is a TikTok that you watched prior to trial, correct? Correct. Posted it on December 13th of 2022. It includes your voice, it includes your picture. Offer it up, no objection, we'll publish. You chose what was said. Professor's attorney, Attorney Olson, sent me a demand letter to remove TikToks with false statements. I made no false statements. Kiss my ass. Which means, what does it mean, TikToker? It means kiss my ass. Oh, I remember. I remember watching people's faces, and and you could tell that they were trying to be so neutral, but some of them wanted to giggle because it was just like so absurd to put in a TikTok. But I don't think the jury, but it was like mainly people in the gallery. They were like, what the heck? And like kind of like wanting to giggle because it's just such an absurd thing to say, especially to a lawyer. But they play the video. And TikToker, that demand letter that you received is the same document that we looked at yesterday in exhibit number 40, correct? Correct. Or 20, sorry, 20. And that demand letter enclosed a copy of the earlier demand letter, the one that we looked at in exhibit number 19, yes. And in that demand letter, both demand letters, simply asked that you take down the videos, correct? That was one of the things it asked. And then it asked you to not post any more making the false statements, correct? That was another thing that it was asked. And then it asked you to apologize, correct? Correct. And you didn't take down the videos, correct? And you kept making videos, correct? And you've never apologized to the professor, correct? Correct. And you certainly didn't, in response to that cease and desist letter in November of 2022, correct? False. That was my response. Your response was the video. The video that ends with KMA. Yes. Well, that's a response, all right. If we could next look at exhibit number 43, and Professor... Oh, she mixes them up. I'm sorry. TikToker, did you watch exhibit 43 prior to trial? Yes, it's another video, correct. And you made this one on or about December 13th. That's possible. And the same time as the one we just looked at in exhibit number 9. It looks like new clothes, so maybe a couple days later. They were all around the same time. No objection. And the type, what does it say? It says, found a good place for the demand letter professor's attorney sent me. Upside down smiley face, and you chose the words to put there, correct? If you would please play exhibit 43. So I have seen this video. I want to say I was looking through videos talking about the TikToker just to see if maybe some people had archived some of the videos. And I want to say it was a Toesies. And she's like sitting in the bathroom and she's like, this is where it belongs. And she like puts it next to the toilet paper. So that just tells you how she felt about this whole lawsuit in itself. But TikToker, after receiving that demand letter and after you made the TikTok, that's in exhibit 9, and after you made the TikToks That's in Exhibit 43. You continued to post on TikTok making the false statements that the professor orchestrated the murders, correct? That's possible. And you continued to post on TikTok making the false statements that professor had an affair with one of the murdered students, correct? That's possible. Your Honor, I don't know what time the court plans to take the morning break. I know we've had a couple of times we've stepped out, but I'm fine with any time. I'm just alerting the court that that would be the court. If you have about another 15 minutes, or if this is the better breaking point, we can break now. No, Your Honor, I can keep going. I just don't know. I just know we've been going for a while. Questioning by Miss Olson. TikToker, I'm next going to have you look at exhibit number 10. And I'll direct your exhibit to the second page of exhibit 10. Does that show the first screen of the TikTok that we've looked at? That's in exhibit number 6, it appears to be. And you're aware that you're posting on TikTok that people can mark if they liked your TikToks? Yes. And you can see if people shared? Yes. Also shows the hashtags? Yes. And exhibit number 10 shows all of those things for the video, the TikTok video we looked at in exhibit number 6, correct? Correct. Your Honor, at this time, I'd offer up exhibit number 10. Any objection? No objection. I'm going to ask you to zoom in just to the part above the thumbnails below. And TikToker, over to the right, where there's a heart, it has 11.9K under it. What does that mean? It means that 11.9K people or accounts on TikTok pressed the heart button on that video, meaning they liked it, correct? It just means they pressed the heart button. Have you ever pressed the heart button on someone else's TikTok? Yes. And what was your purpose when you pressed the heart button on someone else's TikTok? Support or like, or yeah, either one. And then below that, with sort of a thought bubble with 3 dots and 277, that's comments, correct? Correct. And below that, the 128 with an arrow, that's shares. Is that correct? Yes. So that means 128 people passed on your TikTok video that was exhibit number 6 to somebody else, correct? False. It could mean that they shared it in commentary, for example, to go against it or go with it. It could mean that they just pressed the copy link button and saved it somewhere else. It doesn't mean that they actually published it. It just means that they clicked the link, copied it, or they could have shared it. All of those things you just don't know, correct? I don't know. But at least 129 people did one of those things, correct? 128, yes. Fair enough. 128. I should put my glasses back on. Oh, I love, side note, I really enjoy this attorney's style because she's very witty, but in like a, not a backhanded way, but she's very witty in a way that makes you like, especially people who are listening, they're like, ooh, and they kind of just like look at her for a second because it's so sly the way she does it and how she handles certain things that the TikToker says. I don't know. I just really like her style. I saw her a little bit when she was protesting the media order for Kohberger's trial. I think she was the attorney for the media. And I really liked her style then too. I just find it very interesting, like how she handles certain clients and how she handles certain judges and whatever. But it was yeah, I like her style to a certain extent. And TikToker, that was common with your TikToks. They would get heart buttons pushed, correct, correct, and sometimes in thousands of people, some of them, yes. And they would get the arrow, yeah, and then below the number are the number of hashtags, correct, correct. And those hashtags that you selected to go with your, and are those hashtags that you selected to go with your TikTok video, correct? So you selected hashtags about solving mysterious deaths, correct? Correct. That was how you build yourself. Yes. You also selected a hashtag for University of Idaho murder. Correct. That meant people who were looking for the content on the University of Idaho murder, they might then land on your TikToks. Yes. And then it says just University of Idaho, correct, correct. And then it says hashtag Rebecca Scofield, correct, yes. And you wanted to make sure if people were looking for content about or on Rebecca that they would be able to see or could choose to see your TikToks, correct? That's possible. You also used hashtag the other people that you've mentioned, the University of Idaho students and the young man that you said Professor Scofield hired, correct? And these hashtags are topics. It's just topics that go with the video. Yes. Okay. And those are the ones that you picked, correct? I'm next going to direct your attention to exhibit number 11. And TikToker, you had the opportunity to watch exhibit number 11 prior to trial. Yes, this is the TikTok you posted on December 26th. It appears to be an ABC News TikTok or reposted online. So you reposted something on your TikTok. Yes. You made the choice to repost that content. Yes. And you typed the information that's on the first screen of exhibit number 11. Correct, correct. You posted this to your account, my second account. You had posted it to a backup account, right? Right. And that's because your first TikTok account by December 26th of 2022 had been taken down and you couldn't use it, right? Right. Well, when you ban evade, and you posted, it was banned for weeks at a time. And you wanted to post on this backup account in part so that your followers would know where to find you and that you were okay. Correct, correct. Offer up 11. Any objection? No objection on authenticity, but it's not my video. It's an ABC News video. You'll be able, or the court, TikToker, you'll be able to point that out on cross-examination if you wish. TikToker, no objection. All right. The court, all right. Thank you. Will be admitted. Thank you. And on the type that you put over this, what you've called an ABC video, you chose what to put there, correct? Correct. And what did you choose to say? Hey, hand wave, I can't post comments or videos on my main page right now. I'm okay. And Miss Bibb, would you please play number 11? Then TikToker, it was your choice to post that TikTok, correct? Correct. And that was obviously after this lawsuit had been filed, correct? Correct. And even after the lawsuit was filed, you continued to post content alleging that the professor had orchestrated the murders, correct? I would have to verify that. And you continued to post content that the professor orchestrated the murders because she was having an affair with one of the murdered students, correct? Answer, again, I would have to verify that. I know that the amount of videos went down and eventually was like 1 or 2, but it stopped. But there may be a few videos, yes. Okay. And you continue to post content or to make statements that Professor Scofield was responsible for the murders and that Professor Scofield had an affair with one of the murdered students throughout this litigation, correct? In legal documents mostly, yes. That is still making statements. Legal document or not, it's still making statements because all the legal documents are public knowledge. Unless they're sealed. But all of them were pretty much not sealed. And other places, correct? Most of it was regarding the lawsuit and legal documents. And you would assert to those legal documents that, as a fact, Professor Scofield had orchestrated the murders, correct? False. I would assert that I believed that she orchestrated the murders and had a relationship with one of the students. I'll now have you look at exhibit number 17. Number 17, a video that you watched prior to trial. It's a TikTok you posted August 28th, 2025. And this one doesn't actually feature you. There's just some music, text, and a repeated phase, right? Right. You would agree on August 28th of 2025, that was after Brian Koberger had been charged, correct? Correct. After he had pled guilty, correct? Correct. After he had, in a courtroom in the same city, admitted that he killed each of the students, correct? Correct. And after he had been sentenced for those crimes, correct? Yes. Your Honor, at this time, no objection. Miss Olson, I think everyone has to look quick, Your Honor. There seems to be an issue with the system. Maybe now would be a good time to take a break. The court, I think that's a good suggestion. Ladies and gentlemen of the jury, we will take our mid-morning break. It'll be approximately 20 minutes, so if you want to get an early lunch or snack or drink, then we'll resume back here at 11:35. We'll be in recess. The court, please be seated. TikToker, you may step down. We'll try to, on our end, get that working. Miss Bibb, if you'll stick around to help us do that. We'll take our mid-morning recess right now. The court will be in a brief recess. Recess was taken until 11:36. Please be seated. Did we get the video back up and running? I think so. We'll have the jury back in. The jury was seated at 11:38. The court, please be seated. TikToker, if you'll please retake the witness stand, you may be seated. I'll remind you that you're still under oath. Ms. Olson, we left off trying to publish plaintiff's exhibit number 17. That's correct. I think we have that fixed. So I think I'll just ask to publish it now. All right, you may inquire. Thank you, Your Honor. And then she goes into the questioning. Sorry, I'm trying not to gulp in your ears. TikToker, on the first part of exhibit number 17, that's type that you put on there and copied into this TikTok from some other source. Is that right? Maybe I typed it. Or did you know where you got the content that you put on the beginning of the screen in exhibit number 17, which is your TikTok posted on August 28th of 2025? Yes, Idaho State Police report supplement number 7. And so you exhibited material from that and decided to post it on August 28th, 2025. Correct. After Mr. Koberger had been sentenced for the murders, correct? That, yes, because they didn't post those documents until well after. If you could please play exhibit number 17. TikToker, in that video, the center photo, that's also a photo that you selected, the one that we saw before. There was the screen from the report, and then there was a video. Do you recall that? Yes. And then there's what we see on the screen now, which appears to be a redacted report. Do you see now on the screen a photo? Yes. And that's a photo of the professor, correct? And her husband, correct? Oh, Lord. And it's in front of them buying or with a white Subaru at a Subaru dealership, correct? I actually saw this exhibit because I pulled it up after. It's such a stupid, it's such a stupid thing. Because it's just them buying a car. I don't get it. So in August of 2025, you're still posting content linking the professor to the murders, correct? False. And you were still posting content linking professor to one of the murdered students, correct? I posted content on that day about professor, correct? And it was content linking her to the murders, correct? Oh my gosh. Linking her to the murders that you had repeatedly accused her of orchestrating, correct? False. Sorry, I misspoke. False. I believe the content was about the ISP report. And if you go back, I could read it. That actually wasn't my question, TikToker. Okay, so this TikTok that we see in exhibit number 7, where we see the part of it that's on the screen now is a picture of the professor and her husband, correct? Yes. And so on August 28th of 2025, you were still posting content of Professor Scofield in connection with the murders, correct? I posted content on that day, correct? And it was the same murders that you had earlier repeatedly accused the professor of orchestrating, correct? TikToker, do you know what year that photograph was taken? I do not know what year that photograph was taken. 2019? I may have known when I posted it, but right now I don't remember. It's possible that it was 2019. So some 3 years before the murders occurred, correct? Possible. Oh, gravy. Okay. Miss Olson, you can take that down. Question. TikToker, you were aware that the Moscow Police Department issued a press release on December 27th of 2022 after this lawsuit was filed, where they said that the professor who was suing the TikTok artist they don't believe that she's involved in the murders. Do you recall seeing that? Yes. And that was what we looked at yesterday in Exhibit 21. Is that right? Yes. And you learned that Brian Koberger was arrested or taken into custody at the end of December of 2022 or early January of 2023, correct? Yes. That's the time frame you recall, correct? And you made statements after that accusing the professor of orchestrating the murders, correct? and of doing so because she was having a relationship with one of the female students, correct? Correct. I'm going to direct your attention to exhibit number 12. Some of the statements you made after Brian Koberger was arrested were made in a YouTube video that you posted on February 9th of 2023 titled Full Synopsis of the Plot to Kill the 4 University of Idaho Students. Correct. Correct. I actually have this. I pulled it and downloaded it so I don't have to give a review. So if you guys want to see it, I can pull it after my I can pull it later and we can watch it. Exhibit 12. Oh, Exhibit 12 is that correct? It can be, it appears to be. Well, you had the opportunity to watch it prior to trial, correct? The 12 I have is 12A, B, C. It's cut into 3 different videos. Is that what I'm looking at? No. She keeps mixing up the 2 names. I feel bad for her. So prior to trial, you received exhibit number 12, correct? Correct. And you had the opportunity to watch exhibit number 12, correct? The full video, correct? Correct. And you're familiar with the full video, correct? Correct. But I'm just confused because you have a 12A, B, and C. I'm not asking you about those. The email that you and I exchanged, I'm just asking you if you had an opportunity to view the full exhibit number 12, which is your video. My exhibit, defendants, my exhibit, no, our exhibit number 12. And I'm going to ask you to clarify if 12 means A, B, and C, because I'm understanding that you have 3 12s. I'm not asking you anything about anything that says 12A, B, or C. I'm not suggesting anything about that. I'm just asking if you had been able to watch the full video of your YouTube video, correct? Your Honor, at this time, I'd offer up exhibit number 12. Any objection? No objection. All right. And I would ask that initially we put up the first page of exhibit number 12, but I intend to play play portions of it, Your Honor. Question, TikToker. In this YouTube video, we see in number 12, dated February 9th of 2023, you continued saying that Rebecca Scofield had a relationship with one of the female students, correct? Correct. Ms. Bibb, will you please play approximately 2:43 to 4:45 in terms of the timestamp on it? I know it's a little hard to get there, so just a little more. 2:46, plays video. And I think we actually stopped at 4:47, and I think it started at 2:46. TikToker, in the video from February 9th, 2023, the YouTube video, that's exhibit number 12, you also continue saying that professor came up with the plan to have the students killed, correct? Correct. If you would play 7:34 to 9:33, if you could get it back to 7:27 or 7:25, that's fine. If you could stop it there, we actually started 7:25 to 9:33. And TikToker, in your YouTube video, that in exhibit number 12, that one that you made, one of the changes you made about what you were posting is that you started including Brian Koberger in your post, correct? False. You started including Brian Koberger as having somehow been involved in the plan that professor was putting together. It wasn't a change. His name was mentioned, but I had already mentioned another culprit on November 23rd of 2022. That the change was saying his name specifically. If you now play for approximately 24:43 to 29:14, you can take exhibit 12 down. TikToker, you learned that Brian Koberger was charged by way of indictment on May 16th of 2023, correct? False. You didn't learn about him being charged with the murders. Not arrested, but being charged, correct? I don't know what day. You learned that he was being charged, correct? Correct. And after he was charged that formal way, you knew that he alone was charged, correct? Correct. And you learned that no other person was ever charged along with Brian Koberger, correct? And you made statements after May 16th of 2023 accusing the professor of orchestrating murders, correct? I would have to see that. It's possible. You appeared on the YouTube program called The Nerd Report on June 9th of 2023. Yes, you did an interview with the host. Yes, you were sitting in a Maserati vehicle. Correct, correct. I tried to find the Nerd Report video. They took it down. So it is no longer available. Someone probably has it somewhere, but when I tried to go find it, it was gone. I'm next going to redirect your attention to exhibit number 14. TikToker, did you watch exhibit number 14? A little bit of it, but you watched certain excerpts of it a little bit, and you recognized it as your appearance on the YouTube program called The Nerd Report on June 9th of 2023. Correct. Your Honor, we're not going to offer all of exhibit 14. I'm going to offer exhibit 14A. Do you recall looking at exhibit 14A? I looked at 14A. That is a true and accurate excerpt of your appearance on the Nerd Report. Well, it's edited, but yes, it's just an excerpt, right? Yes, and it's just a part of the larger video, correct? Correct. But it's a true and accurate excerpt of that larger video, correct? True and accurate in the sense that it's me saying those words. Yes, correct. Jeez. No objection. Plays video. Did you also watch 14? Yes, yes, no objection. Plays video. Did you also watch 14C prior? Yes. That's also an excerpt. Yes. No objection. Plays video. You also made a video, posted it to your YouTube channel on October 14th, where you referred to Professor Scofield as a murderer, correct? October 14th of 2023, it's possible. And you had over 1,000 subscribers to your YouTube channel, correct? Yes. Do you recall watching Exhibit 15B prior to trial? Yes. And is that an excerpt of October 14th video? It's possible for me to see it before I answer that question. Sure. If you could please pull up the first part. Yes. And that's the post you made on your YouTube channel, correct? I have this video as well. If we want to see that. Django says this TikToker really has me feeling like I want to hit my head against the wall. Yeah, the way she handles some of the questions is just boggling to me. Like, I know what she's trying to do. She's like trying to distance herself a little bit from it to make it seem like, well, back then I believed all this stuff. But it's like, well, you doubled down in legal documents and you were still doubling down in court. So it's hard for me to fully understand, like, well, you were trying to avoid this, but yet it kind of got worse because instead of in court, you were just like, oh, it was just how I felt back then and blah, blah, blah. You kept doubling down in court. So it just got worse and worse. That's the post you made, correct? And that post on the YouTube channel, there's one where you refer to the professor as a murderer, correct? I don't remember. I would have to see the video again. Do you recall watching it? I watched it as well as all the other videos. I don't recall whether I referred to her as a murderer. Exhibit 15B is an excerpt of the video that you posted, correct? Yes. Your Honor, at this time, I'd offer, no objection, plays the video. TikToker, would you agree that in that excerpt from October 14th of 2023 that you referred to Professor Scofield as a murderer? Yes. You can take that down. TikToker, by December 21st of 2023, you knew that the University of Idaho had no evidence or information that the professor had ever communicated with any of the students who were murdered, correct? False. Okay. You reached out to the University of Idaho. Yes. You sent them a subpoena. Yes. You received a response to that subpoena. Yes. And it came from Kim Ryder, correct? Correct. He's the general counsel of the University of Idaho. Correct from my understanding. And if I could direct your attention to Exhibit 28, you recognize 28 as the response that you received from the University of Idaho regarding in response to your inquiry about Professor Scofield's contact with the students. Yes. And you agree that this is a true and accurate copy of that? I believe so. Do you recall receiving it? Yes. All right, Your Honor. At this time, I'd offer Exhibit 28. Any objection? No. They submitted it. And this letter's dated December 21st of 2023, correct? It's addressed to you by email, correct? Correct. It starts out, Dear TikToker, this correspondence is in response to the subpoena to produce documents, information, or objects, or to permit inspection of the premises and a civil action issued by you in the above referred manner and served the University of Idaho. Did I read that correctly? Yes. And then it says, the University of Idaho conducted a search of records within its custody and control to respond to the production request in your subpoena. Correct? Correct. The response to each production request is as follows. Did I read that correctly? Yes. And then it numerically goes through all of the things that you asked for. Correct? Correct. And this is signed by Mr. Ryder on page 2. Correct? Correct. All right. If you need to look, I know it's a multi-page document. I think there's still a binder in front of you at tab 28. And one of the things that you asked for was communication, including deleted communications between professor and the University of Idaho student whom you accused her of having an affair with. Correct? Correct. And what was the response of the University of Idaho? Are we on number 1? I'm sorry, we're on number 2. Okay, number 2. The response is, the University of Idaho did not locate and is not aware of any communication, including deleted communication, to and from Rebecca Scofield and the University of Idaho student, KG. And you have asked the same question about each of the other 3 murdered students. Correct? Correct. And the University of Idaho responded to each of those. Correct? Correct. The U of I indicated that had no such communications, that they were not aware of and did not locate. They didn't have anything to provide you in response to your subpoena, correct? They did not provide me. They provided me with this response, yes, and nothing else, just the response, correct? Yes. And you have no reason to think they didn't look for the documents, right? I did email them a follow-up email asking, hey, you said you were not aware of it and did not locate. Did you actually look for these documents? And they did not respond to me. That is such a rude email. Hey, did you even look for them? They take stuff pretty seriously, so I would assume they would. They would look for those. Oh my gosh. Okay. Whatever, dude. Well, the general counsel responded to you with this letter, correct? And when I responded, he didn't answer. Did you send him a second subpoena? I did not send a second subpoena. He also asked if there were any transactions between professor and students, correct? Yes. And the information you got back as referred in Exhibit 28 is there was no transactions. Which number is that on here? So I'm trying to summarize it a little bit, but let's look at number 3. I can't. Okay, number 3. You asked for communications and transactions between to and from Rebecca Scofield and one of the other University of Idaho students, correct? Correct. And then again indicated we don't have anything, right? I would like to see that before I say, sure, it's number 3. Okay, yes, it said that they did not locate and is not aware of any communication or transactions. And they are questioned, and they had actually said above that they had conducted a search of their records, correct? No response. If you look in the very first paragraph, didn't they tell you we conducted a search of records within our custody and control to respond to the production request in your subpoena, correct? Correct. And they didn't find anything responsive to any of the requests that you made, correct? Correct. And you made 10 requests, correct? I believe so. Well, if we go to page 2, there's 10 numbers, right? Yes. And you also asked about communications with Brian Koberger, correct? Correct. And you asked about communications with the young man you identified in your earlier TikToks in late November of 22, correct? Correct. And you also asked if Professor had attempted to delete, remove, hide, or otherwise restrict access to information regarding her connection with any of the students or Mr. Koberger, correct? Correct. And that's the very last bullet, number 10, correct? Correct. Oh. And what was the University of Idaho's response? Part of me is like very confused on what her tactic is, because I I'm I don't know. Like, part of me is like, is she being obtuse on purpose, Or is she just not fully understanding the questions? Like, part of me doesn't want to believe she's being obtuse on purpose because I'm trying to have like I'm trying to be very unbiased with this because it's just at the end of the day, like, it is what it is. Like, you said these things, you were found liable, and now you went to court for defamations. But what's so hard for me to understand is like it's such a weird way to communicate where it's like, well, I don't know if there's 10, when it's like anyone with eyes, I mean, anyone in general could just look through really quickly and be like, yeah, there's 10, or something of that nature. And part of me is like, is she just doing this on purpose so everything is like laid out, or is she just genuinely not fully understanding? Which, if she's not fully understanding, then that's a whole different ball game. But I'm just not sure what it is, because to me, it's like, well, you're just kind of being rude and being obtuse. But again, it um could also just be a thing where it's like I'm just not understanding. And if that's the case, that's the case. But it just seems a little, the way she's handling it just seems a little odd. I don't know. I truly don't know, but um question, and what was the University of Idaho's response? Answer: the University of Idaho did not locate and is not aware of any communications indicating or suggesting that counter-defendant professor has or had attempted to delete, remove, hide, or otherwise restrict access to information regarding her connection to any of the aforementioned students. And then it includes the names of the 4 murdered students, Mr. Koberger, and the young man you repeatedly said in your TikTok videos had actually carried out the murders. Is that correct? Yes. Or is that right? Yes. And you had all of that information by December 21st of 2023. Is that right? Correct. And you continued making statements after that accusing the professor of the murder, even though you knew Brian Koberger was the only one ever charged. Correct. Um that Harv guy sounds on par with someone that doesn't believe the burden of proof applies to them while trying to get everybody else to do the job for them. Maybe. I don't know. It's just a weird way to handle the questioning, I guess is the right phrase. I don't know. Watching her in court in general was just so odd to me because you know she's pro se, obviously. And like the court has made it abundantly clear multiple times she's pro se, but it was so interesting to watch how she handled the witnesses and handled like even questioning herself. It was very a little bit disjointing sometimes because she would ask fairly good questions for chunks of it. Like, you can tell she's very intelligent. You can tell that she has a lot of understanding with certain things. And what was very frustrating was that she would get on really good tracks of questions, and you could tell that she was like understanding what was going on, and she could ask these really in-depth good questions. And then all of a sudden it was like her emotions or something got involved, and she kind of like faltered or misstumbled and then got into this weird line of questioning, like earlier when she kept testifying instead of just asking questions. And it was so frustrating because as someone who studies, I'm studying criminology, I'm studying criminal justice. It it was so frustrating because it's like, no, 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 you were on the right track. Like, you were asking good questions. Don't screw it up for yourself, because you're just making yourself look awful, I guess, in a way, or like making yourself look off or disjointed to the jury. Which, I mean, like, it's your choice to do what you want, but it was so frustrating to watch And I think I told Atozi a few times, I was like, her questioning can be good. It's just like, it's almost like she chooses not to keep going with that. And I don't know. I personally don't know, and I can't speak for her, but it was just a very frustrating thing to watch because it was like, you had such good questioning, and now you're. I truly think she just got involved with it a little too much, and then she faltered on some of her questions. But it's just so frustrating when you're watching it happen and you're like, why are you asking that? That seems so, like, not in line with the questioning you just had, or it seemed kind of rude, which I mean, you can ask to a certain extent, but it was a weird, it was just weird, I guess is the right phrase. It was just a very weird communication and timeline that we were watching. But, um, yeah. So, includes the names of the four murdered students, and you had all that information by December 21st of 2023, correct? And you continued making statements after that accusing the professor of murder, even though you knew Brian Koberger was the only one ever charged, correct? And part of your online work then was to comment on and reject the other online personalities who disagreed with you, correct? Part of my work, or no, part of your online commentary was to comment on and reject the other online personalities who disagreed with you. I took up for myself, yes. Then on May 1st, 2025, you posted a video and reposted and responded to someone who called himself Mad Caster. Is that correct? Correct. Mad Caster, look at you! You finally appeared! I personally, like, I went back and looked at some of his videos. I think he was very neutral with a lot of the stuff. Like, he focused heavily on the documents like Emily D. Baker and stuff. And I really enjoyed that type of coverage where it was very like neutral and they just wanted to cover. But I do find it funny, like after the fact when I was talking to Atozi, he's like, oh yeah, she wants to like sue me and Madcaster. And I was like, oh, great. And then as I started digging more into it, I found out that I think his name's Marky. Is it Marky? I always think his name is different. I think it's Marky. Like she threatened him too in a lawsuit. I don't know. Yeah, it's wild. I don't know. I don't know. I personally think his coverage was fairly neutral. Um and that was in again May 1st of 2025. Does that sound right? Sounds right. And one of the things you said was he don't know the professor from a can of paint. Do you remember that? I did not see that video. I wish I had it. Yes. All right. You also didn't know Professor from a can of paint, correct? I'm claircognizant, so that would be the difference. He's not. That's not my question. You also don't know Professor from a can of paint, correct? False. You've never met her until this trial, correct? You had obtained information from the University of Idaho and they told you there was no connection between the professor and any of the students, correct? Correct. And all that you knew about her was what you looked up online, correct? And that's not the only thing. And all you knew about her, all the facts you knew about her was that you had looked her up online, correct? The facts were from this legal case. Yes. TikToker, you posted on your Instagram story on July 12th, 2025 that you were in Italy or Greece. Is that correct? July of 2025. July when? 12th of 2025. You don't know the bro. That sentence pains me. It's such an odd statement, but I mean, it is what it is. It's just to me, it's just kind of a funny statement, but it's very odd too. I may have posted it that day, but no, I was not. Where? Italy or Greece? I wasn't in Greece. I was in Italy in June, and you made purchases there. You went shopping until July 3rd. Yes, I was in Italy. You purchased perfume, yes, handbags, a purse, yes, candy, yes, and you posted all of that on your Instagram story for people to see. Correct, correct. TikToker, you have never apologized to Professor for calling her a murderer. Correct, correct. You've never apologized. For saying she orchestrated the murders, correct? You've never apologized for saying that she had an affair with one of the students, correct? You never took down any of her posts or videos saying that the professor was a murderer, correct? TikTok took them down. Right. You never took them down. Correct? Correct. You never took down any of your posts saying that the professor had orchestrated the murders, correct? Correct. Or that the professor had an affair with one of the students, correct? Only TikTok did that, correct? TikTok did that, correct. Ms. Olson, thank you. TikToker, the court. All right, TikToker, you have the opportunity to cross-examine yourself and then answer the question after a bit of a pause to allow any objections that might come. You can ask these questions, but just realize that if you intend to also testify in your case in chief, be a witness, that I probably won't allow cumulative testimony. But I'll give you some latitude there, so you can proceed with your cross-examination. TikToker, thank you. Okay. On to her cross-examination of herself. Question. I will ask myself a question regarding the posted number of videos. I have to speak to myself in third person. TikToker, you posted a number of videos regarding the murder of the students and the professor's involvement. Why did you post those videos? No objections. Oh, Lord. Okay. Answer. I posted, for example, on November 24th or November of 2024. I should note there were 15 videos November 24th or 7 videos November 7th because the videos are limited to TikTok at that time were like 60 seconds or less. So when I would do a tarot reading and get a message, if the message did not fit within 60 seconds, it would require another video. So 7 videos may be a total of less than, it would be 7 or less minutes regarding whatever topic I was speaking on. So the number of videos does not necessarily mean a massive volume because the videos are limited to 60 seconds or less. And as you've seen from the evidence, some of them are even 15 seconds. The court, TikToker, could you just say question and answer? That'll break it up for the record as well. TikToker, okay. Court, thank you. And then back to cross-examination. Question, why were those videos posted? Answer, I posted those videos because I first was requested by a TikTok user to use tarot readings. Ms. Olson, I'm going to object to the extent it's being offered for the truth of the matter asserted. If it's only being offered for what she did in response, I think that's fine. But just so it's clear that anything someone said out of court is not offered for the truth. The court. And that objection will be overruled. As I understand it, you're asking about whether a TikTok user's statement or requesting what she did is hearsay. Ms. Olson, Your Honor, I'm only objecting if it's being offered for the truth of the matter asserted. The court. All right. As I understand it, TikToker is going to testify about why she posted videos, and it was in response to something a TikTok user requested. The jury's not to consider that for the truth of what the TikTok user said, but just to show the reaction of TikToker in response to that. You may continue. Thank you. At the time I was posting videos regarding the suspicious death of Shinquella Robinson, who, Ms. Olson, objection, Your Honor, relevance, and I think it gets into the character evidence that we discussed. The court overruled. And back to TikToker. At the time I was posting content regarding the murder of Shinquella Robinson, and during those videos, a TikTok user said, I'm waiting on you to do a reading on the murder of the 4 University of Idaho students. I believe that to be around November 22nd of 2022. I responded that I would do it. So on November 23rd of 2022, I stopped reporting on the death and began doing readings and postings on my TikTok on the murder of the 4 University of Idaho students. That way I would Oh, okay. She just stopped herself. Question. Okay, question. Where did you get the information that you posted regarding the murder of the students? And we must be missing a page. I know it says 71 to 72, but there might be some objections in there that I missed or that they didn't send me. Question, where did you get the information that you posted regarding the murder of the students and Rebecca Scofield? Answer, I conducted tarot and oracle card readings on basically the hypothesis on who, what, when, where, and why the students were murdered. I used, again, two like oracle cards and tarot cards, as well as public information on the case. For example, I learned of the victim's name, so I would do a question to myself in my notes, like who killed KG, why was KG killed, and I did that for each name of the students. I also was conducting tarot readings and oracle readings. The word history continued to come out in those readings. And as a spiritualist, when you see something repeated, sometimes it's a message. So when I saw the word history, I dug more into it. I asked my tarot and oracle card, why am I seeing history? And I alluded to a teacher. The tarot and oracle reading, tarot and question, what are tarot and oracle cards? Tarot cards and are card decks created by people in the spiritual community that delivers messages. To get a message from it, you shuffle it or pick a card. People do it different ways, but you shuffle it and a card pops out as you're shuffling, and you would take that card. I take that card. Sorry, not you. I take that card and decipher a message from that card. The same as for oracle cards. Question, what message did you receive from the tarot and oracle cards? Again, or answer, again, the messages I was receiving was that a teacher ordered the murder of the students, and she hired two people, ultimately only going with one to execute the crimes. After the word history came out several times and a teacher, I went to the University of Idaho website. That's because that's where the students attended. I looked at the history department. When I got to the history department, it was maybe 10 people listed as faculty on the history department's page. I then took my tarot and oracle card readings in my notebook and I wrote down each of their names, and for each one, again, I conducted a tarot and oracle card reading with the question, what was whatever person that name was. I don't remember all of their names. What was this faculty member's role in the murder of the 4 University of Idaho students? The reading for the remaining faculty members that I did that day came out that various messages, like they were afraid, they were waiting for other people to learn of what happened, general message of non-involvement. When I did the reading on Professor, the reading stated that she was involved with the crimes. She ordered the crimes and she was involved with the students. I was in shock to receive that message, so I did several more tarot readings to confirm the message regarding regarding Professor's role in the murder of the students. And it continuously gave me the message that she was dating a student, and then who, what, when, where, and why. Again, I asked about Professor. It alluded to anxiety, it alluded to not wanting to be caught, it alluded to her involvement with the crimes. At that time, I believe, Ms. Olson, Your Honor, I think we've gotten into a little bit of a narrative. I would ask that we proceed in question and answer. TikToker, okay. The court, that'll be sustained. Just ask another question. Thank you. Question. After receiving the message of the tarot and oracle cards regarding Professor's involvement with the murders, why did you post those readings and tarot and oracle card readings on TikTok? Answer. That goes back to the initial post of the TikTok user who asked me, what, can you do a reading on the students? 2, also, I thought it was important information that I believe someone was involved in the crimes and that the public should know. Question. Why did you post multiple videos? Answer. Again, multiple videos are posted. 1, because of the limited 60 seconds or less videos that I had to post on TikTok. And 2, I really wanted the message to get out there that the professor ordered the murder of the students because there were no arrests at the time, and I believe it to be true. Question. After there was an arrest, why didn't I apologize to Professor? Answer. After Brian Koberger was arrested, I did another tarot and oracle card reading on his involvement. I wanted to see if the reading came out contradictory to the ones that I had already done regarding the murders. Instead, it added to the story. On November 24th of 2022, my reading stated that she had 2 options, and after Koberger's arrest, my reading stated he was one of those options, and my reading said he did not do it. What? Okay. I continued to post because I did not believe the narrative that was being pushed by law enforcement and the media regarding the actual person who ordered and murdered the U of I students again. So I posted to get help. Maybe they would listen. Maybe someone in law enforcement or somebody with power or somebody with knowledge of the case would look into it. Question, were you contacted by law enforcement or anyone regarding your statements of professors' involvement? Answer, I also submitted a tip to the FBI tip line several times. Ms. Olson, Your Honor, I'm going to object as to non-responsive. Her question was, were you contacted, not whether she made contact. Answer, the court, I'm going to overrule the objection. She just kept talking. Just kept going. Okay. Answer, I submitted a tip to the FBI tip line regarding what I believed happened to the students and the real culprits. I did not receive a response from law enforcement. Question, again, why didn't I apologize to professor? Answer, the public information on the case was being limited. There was a gag order in place on preventing information from being presented to the public regarding the details of the case. I submitted inquiries to the FBI. They were not responding. My readings, which I believe 100%, were not contradictory to the information that was coming out to the public. We're not contradictory to the information that was coming public to the case. Sorry. For example, my reading on who, what, when, where, and why the students were murdered stated that the students were separated into 3 rooms. The roommates were in a room. K and M were in a room, and X and E were in a room. When the information came out from a press release from the law enforcement, some of my readings were confirmed, in my opinion, to be true. Ms. Olson, Your Honor, I'm going to object on grounds that inherently includes hearsay. The court, I'm going to overrule the objection. She's not offering that to prove the truth of that statement, but rather to explain her state of mind. You may continue. Ms. Olson, Your Honor, may we approach the court? You may. And then we go to sidebar. Ms. Olson, Your Honor, there's inherently, when she says it's confirmed, it was consistent with my reading, that inherently is relying on the fact of her assertion that what was said in whatever document she's referring to, and we don't know what it is, that there were statements in that were the same as her reading. The court, you can cross-examine. You can cross-examine her about that on redirect. She's explaining what was in the public record that to her, in her belief, confirmed her tarot and oracle card readings. And that is a punitive damages case that goes to her bad faith, and she's got a right to explain what was in her mind at that time. And what was in her head at the time was in part coming from public information that was being released to her. So that'll be my ruling. You'll be able to go into it on cross-examination. Ms. Olson, so she doesn't have to actually introduce the things that were, or the information that she relied on. She can just say, this is what the document says and it confirmed my readings. The court, well, she, TikToker, the court, wait. That is the one thing that I actually liked about the judge. He was very much like, please don't talk over me. Please don't talk over each other. Please have respect. He was very much like, everybody needs to be respectful. Please use your brain to be respectful. So she's explaining what was in her head at the time, just like your client explained what was in her head at the time in terms of how she was feeling and her damages and things of that nature. She was explaining what it is that was in her head at the time, and that's just as much evidence from the witness stand as if there's a document. Again, you can ask her on cross-examination what she relied on. Do you have that here in court? Have you produced it in court? Or have you produced it in trial? All those things. Miss Olson, understand, Your Honor, but I don't want to disrupt the proceedings repeatedly, but I would like to have a standing objection anytime she refers to a document and quotes from it, or refers to it and then says that confirmed or it confirmed my reading, because I think that is inherently hearsay. The court, I don't think she's offering it to prove the truth of what is in the document, but solely as it went to her state of mind at the time. Miss Olson, I think she is offering it, Your Honor, because what she's saying is there was a document that said X, and that was consistent with what was in my reading. The court, and Miss Olson, so the fact that the document X or that the document said X, she is referring for the truth of the matter asserted. The court. And if you wish me to at the end, and I'm already giving a limiting instruction that says, the reason this is relevant is to her state of mind, not for the truth of what the document says. Miss Olson, I would appreciate that, Your Honor. The court. I can do that at the end. Miss Olson, that's fine. The court, remind me to do that at the end, and I'll give the limiting instruction. TikToker, I can bring my laptop over and introduce exhibits, but I was listening to you guys, and you didn't want my testimony to be redundant. The court, yes, and it's up to you how you want to handle your testimony. But all Attorney Olson is saying is that whatever documents or statements, say in this instance, a statement by the FBI or a statement by the Moscow Police Department that you relied on and said that this corroborated my spiritual readings, I would just instruct the jury to say that whatever information you got from public records, from FBI, from Moscow Police Department, you are not offering that today to prove the truth of what the FBI said, to prove the truth of what the Moscow Police Department said. But just as you saw that or read that in real time, that to you affected your state of mind insofar as it made you believe that your readings were accurate. TikToker, yes, sir. The court, all right. TikToker, may I grab my laptop just in case? The court, you may. End of sidebar. The court. And ladies and gentlemen of the jury, you may be seated, TikToker. The objection that Miss Olson had is that TikToker is now testifying about facts in the public record, whether it be a statement by the FBI or a statement by Moscow Police Department, that for her, in her mind, confirmed some of her tarot and oracle card readings. I'm going to instruct you that what she says from the witness stand here about out-of-court statements by the FBI, Moscow Police, anyone, are not being offered to prove the truth of the statements, but simply as they affected her state of mind back at the time she was doing her tarot and oracle card readings. So the objection will be overruled. With that limiting instruction, you may continue, TikToker. And then TikToker, I'll ask additional question. Okay. So what I find very interesting too is that she did submit a bunch of stuff. Like she submitted an FBI tip line, she submitted a bunch of, but it was like not years. I think one of the tip lines happened in like 23, but it didn't happen right away. She kind of waited on it. So I would be curious to see why she waited. I know like later on in her testimony she explains some of the reasons why she waited on certain things, but I'm so confused. Like, if you're getting all of this stuff, why aren't you submitting, like, personally, right? If I did a reading and I saw that for whatever reason I was getting a reading about a teacher in history and stuff, I would have submitted a tip line right away, been like, hey, I know you probably don't believe in psychics. I'm so sorry to send this out, but I genuinely think that this person might be involved. Can you please look into them? Like, even if they don't take it up, at least you submitted a tip and you can prove in a court of law that, like, yeah, I tried. Anyway, question. What is a documented example of information that you received from oracle and tarot card readings in the case that made you believe it matched with the information coming out on the public record? Answer. On December 10th of 2022, I submitted a tip to the tip line at CI Moscow for what I believed the killer and motive of the 4 University of Idaho students. I'm sorry, I need to get this technology. The court, TikToker, do you need some time to get your computer up and running? TikToker, I'm here now. The court, okay. TikToker, okay, well, I thought I had it. It's blank again now. The court, why don't we just take a 5-minute comfort break? Right now, it's a good time for us to break while you get those things organized. We'll take a brief recess for a comfort break. Stepped out, step back in. Please, the court, please be seated. All right, TikToker, are you ready for the jury? TikToker, yes, sir. The court, Ms. Olson. Ms. Olson, yes, Your Honor. The court, please be seated. Are you ready to continue? The TikToker, yes, sir. The court, all right, you may. Question, or a reminder of the question, why didn't I apologize? At the time, answer. At the time, the public information on the case was limited, but sometimes when information was put out, it confirmed my tarot card readings. And other times when information was put out, it would confirm that the message, in my opinion, I got in my tarot readings was accurate when the public information put out in the case was not. For example, I'll introduce Defendant's Exhibit 518. The court, hold on. You said 518. Yes, sir. The court, Ms. Olson, any objection to the admission for Defendant's Exhibit 518 other than discussed at sidebar? Your Honor, none. The court, all right. You're offering that into evidence. The TikToker, yes, sir. 518 will be admitted. Do you wish to publish? Please publish. All right, it will be. It's up there. Answer, this exhibit is a press release from the state of the Moscow homicide update labeled Moscow Homicide Update Clarification, dated November 30th of 2022 at 7:15 p.m. It states the Moscow Police Department is providing the following information to update the public on the known facts surrounding the murders that occurred on November 13th in Moscow, Idaho. They updated the public on several things, but I'm going to limit it to save some time on the purpose of this testimony. The update stated that the roommates and the victims were asleep the night of the murders and that the roommates did not hear anything. From this document, there's a lot of other information that was released, but I want to focus on that. My tarot reading stated that the surviving roommates were not sleeping the night of the murders. The court, TikToker, oh, I'm sorry, so sorry. What? And that they heard everything. The tarot reading video was not produced as evidence, but I do have my initial email to the FBI tip line that states that information, which is Defendant's Exhibit 518. TikToker, please present. The court, are you seeking to admit 512? I seek to admit 512. Miss Olson, no objection. The court, all right. 512 will be admitted. You may now publish. This exhibit 512 is my email from December 10th to the FBI tip line of my attempt to give them the information that I believe led to the murder of the 4 students. For the sake of this testimony, which is focused on my reason for not apologizing, I want to focus on the roommates, the question regarding the roommates, or the comment regarding the roommates. In my statement or tip to the FBI and Moscow PD, I said that the roommates, the surviving roommates, heard everything. They came to investigate while X was alone with E, quote unquote, he was dead, and confirmed their suspicions. Their car was stuck in the mud, so they felt they couldn't get away to go get help. They told X they'd get her help, and then they left her. Instead, they hid until it was all over. That was sent to them again December 10th of 2022. TikToker, sorry, thank you. Now I would like to introduce Defendant's Exhibit 516. Any objection? Miss Olson, yes, Your Honor, on authenticity grounds. I'm not sure, quite frankly, what this is. The court, TikToker, if you could ask yourself some questions in Q&A format and identify what this document is and where it came from. Question, what is Defendant's Exhibit 516? It is a statement from Brett Payne, who states that it was taken from a public record that states he is the court. Don't say what it says yet. What is the public record? TikToker, Moscow Police Department records regarding the murder of the 4 University of Idaho students published on their website. The court, all right. Any objection, Miss Olson? Miss Olson, Your Honor, may I ask some questions in aid of objection? You may. TikToker, when did you get the document that you marked at Exhibit 516? The document is dated December 29th, 2022. So my question is, when did you get it? Around that time? I can't tell you what specific date. Miss Olson, appears to be a search affidavit of some sort. Is that right? TikToker, it was part of the probable cause affidavit. It had to have been after Koberger was arrested, and it was published December 29th of 2022, or filed, as the stamp says, from the District of Latah County, so it had to be after that. Ms. Olson, and Your Honor, subject to the court's earlier limiting instruction, I'm not going to object to this exhibit. The court, all right. Defendant 516 will be admitted. The court, again, ladies and gentlemen, this appears to be part of the complainant affidavit for the arrest of Mr. Koberger. I think there's a lot of factual statements in it. TikToker is offering this as it goes to her state of mind at the time she was making some of these TikTok videos and publishing them and performing her tarot card and oracle card readings. The facts that are in this exhibit are not being offered for the truth. You're not to consider them for the truth or what is being stated, only as it went to TikToker's state of mind at the time and how they affected her state of mind. So, with that, again, Defendant's Exhibit 516 will be admitted. May I publish it? You may. And then back to TikToker's thing. So to bring it back, the Defendant's Exhibit 518 stated for, do you mean it? 58 says, yes, sorry. So if we go back here, it stated that the roommates were sleeping and the two did not wake up until that morning, alluding that they didn't hear anything. My email to the tip line from exhibit number 512 stated that the roommates heard everything, and that is dated December 10th of 2022, but the tarot readings were done November 23rd of 2022, and up until this date of the email. They came to investigate, found X was alone and everything I stated earlier, and they hid until it was all over. Now, Exhibit 516, which is the statement from law enforcement released after the arrest of Brian Koberger on December 29th of 2022. After that, page 4 confirms on, well, page 4 states, and it confirmed in my mind that despite receiving information that the roommates were sleeping, that my tarot readings were correct. They were awake. They did hear a male say something to the effect of, "It's okay, I'm going to help you." They did see X that evening crying in her room, and there's more, but I'm going to stop there for that exhibit. The purpose of showing you guys these 3 exhibits. Okay, sorry. Ms. Olson, Your Honor, objection, argument. Question the court. You can't make argument at this time, but asking yourself a question that is relevant and answer that question. And then back to the TikToker. Question: what does those 3 exhibits have to do with not apologizing to professor? Answer: as I was receiving information from the case first that contradicted what was in my tarot reading, and then, for example, 518. Excuse me, stated that the roommates were asleep. My tarot reading said they were up and figuring out what was involved, and they heard everything and they hid. But then when the probable cause affidavit came out in 516, it explained that despite what law enforcement had put out, what I read in my oracle and tarot and oracle card readings were accurate. And that's when I saw that there was an objective bias to clarify things that I was seeing in my tarot readings. I was less inclined to simply believe I was wrong in my tarot readings just because Brian Koberger was arrested. Question: why did I keep posting? Answer: again, I had a strong belief in my tarot readings, and at the time there wasn't information being released in the case. And in 2025, when the gag order was released and still documents were becoming available, that again, in my opinion, confirmed some of the information that I put out in my tarot readings. I'm not saying that I can't be wrong. What I'm saying is because the information was hid from or under seal and not released to the public from November or from his arrest in December of 2022 up until current, where a lot of the documents are under seal in 2025, when more were being released, I had no way of knowing or receiving objective information that made me believe that what I was seeing was false. So because information was being hidden from the public or sealed from the public, I relied on my intuition and my faith that in examples like this, I was correct even though the public information put out was wrong, that what I was seeing was true. Additionally, it was very hard. It was very hard for me to simply apologize and move on because after doing so many tarot and oracle card readings on the students, it touched me. I felt emotionally invested in solving or helping to solve the murder of the 4 students and also wanting justice for them. And at the time, I believed that Professor was a murderer, so it was in my heart to apologize to someone. Oh, it was not in my heart to apologize to someone who I believed was a murderer. TikToker, that will be all. The court, all right, no further questions. TikToker, no further questions. The court, all right. Miss Olson, redirect examination. Miss Olson, yes, please, Your Honor. And then on to Miss Olson's line. TikToker, murder is the serious crime, correct? Yes. You knew that on November 23rd, 2022, when you started posting about the University of Idaho murders, correct? Yes. You knew that on November 24th, 2022, when you posted the TikToks we've looked at in exhibits 41 and or 40 and 41, correct? Sorry, yes. And you knew that a conviction for a murder carried very, very serious penalties, correct? Yes, including life in prison potentially, yes. And you knew that the murder of 4 individuals would be treated more seriously than murder of a single individual, correct? Yes. And on November 24th of 2022, when you started posting about Professor, you had not a single fact that indicated she was in any way involved in the murders, correct? Answer, psychics don't go off facts, psychics go off intuition. Well, you know what facts are, TikToker. I know what a fact is. So a fact might be that Professor was not in Moscow, Idaho, November 12th and 13th of 2022, correct? False. Professor says she got there November 13th at 1 p.m. That would be a fact, correct? Correct. And you know what a fact is, correct? Correct. And you know that murders can only be charged and prosecuted based on facts, correct? Yes. And you didn't have a single fact that in any way connected the professor to their murders, correct? Again, I was using intuition, not facts. That wasn't an answer to my question. My question was, you didn't have a single fact that connected the professor to their murders, correct? Correct. And you didn't have a single fact that connected Professor Scofield to the one murdered student you alleged that she had an affair with, correct? Correct. And you know how to look up information. Like you went to the University of Idaho website and you could figure out what Professor Scofield's job was, correct? Correct. And that was a fact, correct. And you looked up information about the young man that you alleged that she hired. Yes, and at the time you looked up information that you found online and in media that he had previously had a relationship with one of the young women that you then accused Professor Scofield of having a relationship with, correct? That was long, sorry. You learned that the young man you accused, correct, that he had previously been involved with or was the ex-boyfriend of the same young woman you accused Professor Scofield of having an affair with, correct? After my tarot card readings, or are you asking before my tarot card readings? I'm asking if you looked that up and found that as fact. Alleged fact, yes. So that was information you found somewhere online or information about their prior relationship, correct? Correct. Once you had this tarot card reading, what steps or due diligence did you perform to determine whether or not Professor was even in Moscow when students were killed? My tarot readings and oracle card readings stated she ordered murders, so I felt no need to look up her location the night of the murders because cell phones exist. So you didn't do any due diligence to see whether or not she was in Moscow when the murders occurred. Correct? You didn't do any due diligence to see if she even knew the young man she hired. Are you speaking on November 24th or are you speaking after? On November 24th, before you posted anything that connected her to that young man, what due diligence did you do before or after your tarot card readings? What due diligence did you do to see if the professor had any relationship with that man? All I did was a tarot and oracle card reading. So you didn't look to see if there were any facts to confirm that tarot card reading? No. I mean, I looked, other than looking up the University of Idaho website, no. And when you looked at the University of Idaho website, you picked out the professor, correct? False. I told you. I looked up and did a reading on each and every person that was on that web page. And the rest of them, my tarot reading revealed or stated the message was that they were not involved, and my tarot reading on the professor stated that she was involved. And after that, you did no due diligence to find any facts to see if your tarot card reading, in fact, had facts to back it up so that if you were going to accuse somebody of a crime, that was evidence that could be used in the process, correct? That was the point of my tip to the FBI because I believe there are the fact finders in criminal cases, and in this case, the MPD, not the public. Well, you posted your TikToks, I think, a significant number, 15 on November 24, correct? Correct. and then multiple the next day on November 25th, correct? Generally about the murders and about the professor. You alleged that she had orchestrated them, and some were about the professor, and some were about the professor having had a relationship with one of the students, correct? And there were as many as 10 on November 28th of 2022, correct? Regarding the murder of the 4 students generally. And Professor Scofield, you posted 10 videos on November 28th of 2022 about the videos and about professor's involvement in them, correct? All of the videos were not about the professor, but yes, some of the videos were. And the only person you ever named in any of your TikToks that you alleged orchestrated the murders was the professor, correct? Correct. And in all of the videos that you did, the only person that you ever said actually murdered the students was the young man who was in those videos, correct? Correct. And you never posted a video saying that Brian Koberger actually committed the murders, correct? I never said that. TikToker, you've talked about your FBI tip line. Let's look at that. I think it's Exhibit 512. Miss Olson, in your honor, I think that's in the evidence. That's an evidence. So if it may be published, the court it may. Back to questioning. TikToker, if you go to the very upper right-hand corner, that is the email you sent, correct? Correct. And it's dated Saturday, December 10th, 2022 at 3:54 a.m. Is that correct? And that was more than 2 weeks after you first started posting TikToks stating that the professor had orchestrated the murders, correct? Correct. And that was more than 2 weeks after you had posted on TikTok that the professor was having a relationship with a female student, correct? Correct. And between November 24th and December 10th of 2022, what facts had you gathered to show that professor was in any way involved in the murders? Again, as they call it psychic, I say claircognizant. We worked with intuition, not facts. But when you were on TikTok, you were stating, as a matter of fact, that professor was the murderer, correct? False. In my TikToks, I was holding up tarot and oracle cards, which would imply it as a tarot and oracle card reading, which is not a fact. Ms. Olson, if we could please look at number 40. You remember number 40. Can we please play number 40? TikToker, there's no reference to a tarot card in Exhibit 40, correct? False. My channel was a reference to tarot and oracle card readings because that is what my channel on TikTok was used for. That wasn't my question. So no, that's false because I posted that in the form that I posted tarot and oracle card readings. That makes no sense. I don't think that was an actual answer. TikToker, exhibit number 40. You chose what to say in that video. Correct, correct. And at once, in that video, do you refer to a tarot card reading or an oracle card reading? Is that correct? Correct. Oh my goodness. Let's go back to 512. 512 is your FBI tip line sent more than 2 weeks after you first started posting your TikToks. Correct, correct. And in this tip line, is there a place where you tell whoever you're sending this to, hey, I got this through an oracle card reading or a tarot card reading? No. You just provide what you set out here as facts, correct? As a tip. Right. Well, you assert in the very first line, co-conspirators, professor ordered the execution of, and then you list 2 students, correct? Correct. At that time, did you ever have any facts that the young man you identified had ever been at the house on King Road on November 12th or 13th? By fact, do you mean, did I have any documents? Or, I understand you said you had your tarot or oracle card readings, correct? Correct. And you said that you know that tarot and oracle card readings are not facts that can be used to prosecute someone, correct? Correct. So my question is, do you have any facts that the young man who had been at the house on November 12th or 13th, setting aside your tarot card readings, any facts? The online information that he was her ex-boyfriend would imply that he was at their house, but I had not seen him personally in that house. And you hadn't seen any fact, any report, anything, including in that November 30 press release that we looked at in 518. That would suggest that the young man had ever been at the house, correct? False. And he didn't present In 512, you don't present any of this on the tip line as having been from a tarot card reading, correct? It's not required. We don't have to tell them where we get our tips from. Well, you didn't tell them, right? Correct. You assert certain things and provided that as your tip that you wanted them to follow up on, investigate. I wanted them to investigate them at least. And at the time, I take it you didn't know that Professor Scofield had called the police department on November 24th of 2022, correct? Correct. And you didn't know that she had periodically after that called the police department to update the police department, correct? I had no knowledge of that. And you didn't take any effort to find out any of those facts. The facts is the job of the law enforcement, not a psychic. Oh my gosh. Oh. With respect to 518, that press release that we looked at, 518 doesn't have a single fact in it that refers to professor or a history professor or anyone having ordered the murders, correct? I don't believe so. In 516, that probable cause statement that you say you got on December 29th of 2022, the probable cause statement that you got through public records, that doesn't say a single thing or have a single fact in it that in any way suggests that Professor Scofield was involved in the murders, correct? Correct. And it doesn't have any information in it to suggest that anyone other than Brian Kohberger was involved in the murders, correct? False. Brian Kohberger is the only person that it identifies of having been involved in the murders, correct? Correct, but this says, described as a fugitive, a 5'10" or taller male could be anybody 5'10" or taller that's a male and not very muscular, with bushy eyebrows, And have you seen pictures of Brian Kohberger after the arrest? Yes. And he was tall and thin, correct? I don't have an opinion on that. He has a lean build, correct? Don't have an opinion. Don't have an opinion. Don't have an opinion. She doesn't have an opinion on his looks, pretty much. And the young man you accused of murder, he had blonde hair. I believe so. I'm not sure. And TikToker, you would agree, though, that there's nothing in Exhibit 516 that in any way suggests that there was any information that law enforcement ever had implicating Professor in any way, correct? I don't have, you said, can you repeat that? I'm sorry. Sure, 516 doesn't have any information in it whatsoever that in any way suggests that the professor was involved in the murders, correct? Yes. Or that a history professor was involved in the murders, correct? Correct. Or that anyone had orchestrated the murders, correct? Maybe. And you have never seen, you have not ever seen a single fact that in any way suggests that Professor Scofield was involved in the murders, correct? I requested facts in the evidence and I was denied. That wasn't my question, TikToker. You have not received any facts, correct? At that time, it was on a gag order, and again, I did not receive it. I requested it and was declined. Well, you're aware that there's no longer a gag order in the case, correct? There are still documents under seal, so sorry if I'm saying gag when I mean sealed. And you've looked at records that have been unsealed, correct? Correct. And you haven't seen a single fact that would in any way suggest that Professor was involved in the murders. Correct? Again, I requested it, but I was not, they denied me access to those documents. So no, I do not have it. And you didn't start requesting any of those documents until this lawsuit had been filed, correct? The lawsuit was filed 29 days after I posted my videos, so not a lot of time. And the lawsuit was filed before anyone was arrested. There was nothing to request. So you didn't request or start looking for any such information before the lawsuit was filed, correct? I submitted the tip to the FBI line December 10th. That's at the time you would submit the tips, but there was no documents to request. You didn't, my question was, you didn't get any information prior to the time the lawsuit was filed indicating Professor was involved, correct? There was no information. And in fact, in the 3 years and 3 months since you started posting TikToks accusing Professor of the murders, you haven't seen a single document that in any way provides a fact that would support that Professor Scofield was involved in the murder, correct? False. I've requested documents that I intend to introduce into evidence during my testimony in the future or tomorrow, whenever, that I did see some things that I had questions about and I requested some factual based documents. That wasn't my question. You hadn't seen a single document that in any way provides any fact or suggests that Professor Scofield was in any way involved in the murders, correct? That's false. What document have you seen that suggests that Professor was involved in the murders? There were documents that were under seal that I requested, specific exhibits or specific documents that was held by the police department for me to receive. I did not introduce that into evidence at this time because I was only speaking on my state of mind in the beginning. But I do plan to introduce those documents that state specific evidence or potential evidence that could prove what I was saying about school professor, or that could prove me wrong. So your testimony, what you're telling this jury here this afternoon, is that when you testify in your own case, you will introduce a document that provides evidence or facts that professor was involved in the murder. I will. You asked me, have I seen a document that could suggest that professor was involved? There were documents that were released or under seal regarding the Koberger case. I requested those documents. They could be documents that connect professor to the crimes. However, I was denied access to those documents, so no, I do not have that as evidence. The flip-flopping is wild to me. So you will not, and you have not actually seen a single document or single fact that suggests that professor was involved in the murders, correct? Correct. And you haven't seen a single fact for the 3 years and 3 months since you first started posting TikToks about her, correct? The documents are under seal, so that wasn't my question. It wasn't like I didn't receive any documents. The documents are under seal, so none, general public, did not have access to the evidence in the case of the murder of the U of I students against Brian Koberger. My question, TikToker, is in the 3 years and 3 months since you first started posting on TikTok that professor orchestrated the murders of 4 students at the University of Idaho, you have not seen and do not have a single document or other piece of evidence that in any way connects the professor to the murders. In 3 years and 3 months, those documents have been under seal. You don't have a document that connects the professor, correct? Because they're under seal and I was denied access. So your answer is yes, no, you don't have any document. It's impossible. It's under seal. So it's your position that there are documents still under seal that would tell the world that the professor orchestrated the murders. Answer could be possible is what I'm saying. It could prove that I'm wrong. It could also prove that I was right. And at this point, you don't have a single document and you're not going to introduce a single piece of evidence that shows that you were right, correct? No, because this is only on damages, or this is on damages only. We're not here to prove my statements regarding the professor's role in the murders of the students or the affair was true. We're only here for damages. Ma'am. Okay. Miss Wilson, all right, thank you. The witness, you're welcome. The court, all right. TikToker, you may step down. Members of the jury, I think it's a good time for us to take our last late afternoon break. It'll be another 20-minute break, and then we'll finish up the day by 3 p.m. So if you come back around 1:55 or so, we'll do that, give you about 20 minutes to relax, and then take care of some affairs before you finish up the court day. The jury is excused. The jury exits the courtroom. Please be seated. All right, Miss Olson, who will be your next witness? Mr. Carnan. Your Honor, we're going to adjust our order just a little bit to accommodate travel schedules. I know originally we said Mr. Hanson will be next, but it'll be actually Mr. Ryder. Okay, how long do you expect that witness to take? Mr. Carnan, I think he'll be relatively short, Your Honor, maybe 15 or 30 minutes at most. The court, okay, and then we're presuming we get done with him. Who will be your next witness after that? Mr. Carnan, Sean Quinlan. All right, Mr. Carnan. Ms. Olson, anything that we need to bring up at this point? No, Your Honor. TikToker, no, sir. The court then will take a 20-minute recess and be back at 1:55. Recess was taken. All right, so I'm going to stop there. I really wanted to get all of the rest of it, but I think, yeah, I have a little bit too much to actually take the rest of it. So I'm going to leave that there. I have a VA meeting that I have to go to at 1. So I gotta scoop my booty to get that done. But I will, after my meeting, I think my meeting ends at 2. So once I get back, I'll go live again, and then we'll finish up day 2. I only have about, well, let me double check actually. I only have a few, I don't know. I only got about 55 pages. I don't know how fast I can go though, because I gotta leave the house in like, we'll try. We'll try. We'll try. We'll see. We'll see how fast I can get this done. But I have to leave here no later than 12:45. So we'll see. We'll see how fast I can get this done. It's about 55 pages. It's not too long, but again, it's still a chunk when you're reading. All right. Okay, so then they call Kim Ryder. And then we hop into the direct examination by Mr. Carnan. Good afternoon, Mr. Ryder, sir. How are you employed? I'm a general counsel at the University of Idaho. How long have you worked at the University of Idaho? Next month will be 9 years. And have you always worked in the general counsel's office? Yes. Does your responsibilities at the University of Idaho include responding to subpoenas? Yes. When the University of Idaho receives a subpoena, does it go through an investigation to find responsive emails and documents to respond to that subpoena? I wouldn't call it an investigation, but yes, when we get the subpoena or public records request, we do an inquiry within the institution, what the records are, where we would find them, do we have them, that kind of thing. Is it a thorough process? Yes. Is the intent to make sure that the University of Idaho's response is accurate? Yes. Do you know whether TikToker received a subpoena or served a subpoena on the University of Idaho in relation to this lawsuit? Yes, she did. Were you responsible for coordinating the response to that subpoena? Yes. Your Honor, it's already been admitted, but I'd pull up Exhibit 28, please. Please publish. Do you recognize Exhibit 28? Give me a minute. Yes, it looks like my response. There's a second page, but I don't see. Oh, there we go. Yes. Who drafted Exhibit 28? I did. Who signed? I did. And in Exhibit 28, do you see that there are numbers and bullet points? Yes. What are the numbers? The numbers are the requests or the demands in the subpoena. What are the bullet points? Those are my responses. So when TikToker subpoenaed the University of Idaho, you had to go through the various emails and documents and records in the University of Idaho to provide those bulleted responses. Yes. Do questions number 2, 3, and 4 ask for all communications between professor and the 3 of the 4 University of Idaho students who were murdered in November 2022? Yes. Did the University of Idaho go through Professor Scofield's email account and other records to provide the responses to those questions? Yes. Did the University of Idaho find any responsive communications? No. Did question number 5 ask for all communications between professor and the young man? Yes. If you know who is the young man, he's a student. I haven't thought about that name in a while. He was identified by, I believe, in the media as someone of interest. Did the University of Idaho need to go through Professor Scofield's email accounts and other documents to provide a response to question number 5? Yes. Did the University of Idaho find any responsive communications? No. Did question number 7 ask for all communications between the professor and Brian Koberger? Yes. Did the University of Idaho need to go through Professor Scofield's email accounts and other records to respond to question number 7? Yes. Did they find any responsive communications? No. Did 8 and 10 ask for any communications or documents suggesting that professor had deleted or hidden evidence with her interactions of the 4 victims? of the young man or Brian Koberger? Yes. Similar to that, did the University of Idaho need to go through all of those records? Yes. Did the University of Idaho find any responsive communications? No. What is the exhibit date? Or what is the date of exhibit number 28? December 21st of 2023. Did you send 28 to the TikToker on that date? Yes. Did the University of Idaho receive a subpoena from Professor in relation to this lawsuit? Yes. Were you responsible responding to that subpoena? Yes, I was. Mr. Carnan, this one has not been admitted yet, or it has not yet been admitted, Your Honor, but I'd ask Ms. Bibb to pull up for Mr. Ryder exhibit number 27. Do you recognize exhibit number 27? Yes, it appears to be the subpoena we received. Can you scroll through each of the pages for Mr. Ryder? Does exhibit number 27 also include the University of Idaho's response to the subpoena? Yes, it does. Who drafted this response? I did. Who signed it? I did. Number 27, is number 27 a true and accurate copy of the subpoena that U of I received and the response provided to it? Yes. And did you write the information that's on University of Idaho's response at or near the time you received it? Yes. Was this subpoena kept in the course of regularly conducted business at the University of Idaho? Yes. And is it regular practice of the University of Idaho to document subpoena responses in this way? Yes. Mr. Carnan, Your Honor, at this time I'd offer exhibit number 27 into evidence. The court, any objection? No objection. It's admitted and published. Similar to what we saw in exhibit 28, do you see there are numbers and then bullet points? Yes. What are the numbers? Those are the requests or demands in the subpoena. And what are the bullet points? My responses to those. Can you please read the first question out loud? Please produce all documents and communications indicating that professor ever taught a class at the U of I that was taken by any of the student of the victims or of the young man. What was the University of Idaho's response to that question? The University of Idaho has no record of the victims or the young man having taken any classes at the University of Idaho which were taught by professor. And then do you see questions 2 and 3 ask about any formal investigations? Yes. Okay. Do you understand a formal investigation to be something different than the process that the U of I goes through to respond to a subpoena? Yes. In a formal investigation, would there need to be notice provided to the accused in a process that's followed? Well, there would be a due process at the end of a formal investigation, but yes, we would have a formal investigation. In my mind, it's interviews, those kinds of things. The University of Idaho still did go through a formal process to review professors' emails, documents, and any other records in the University of Idaho to provide full and completed responses to the subpoena in exhibit number 27. Yes. Similar to what it did in the subpoena or the subpoena response we saw in exhibit number 28. Yes. Mr. Carnan, I don't think I have any further questions, Your Honor, at this time. All right, thank you. Any cross-examination? TikToker, yes, sir. And then we switch to cross-examination. Good afternoon, Mr. Ryder. Good afternoon. Do you recall receiving an email from me after you responded to my subpoena? Not offhand, that was a long time ago. And I'll say some of the emails to see if you can remember. In the email sent December 21st, after I received the subpoena, I asked, please clarify whether the University of Idaho conducted an investigation on professor's alleged connection to the 4 students who were murdered. Mr. Kernan, objection, Your Honor, to the extent that she's reading a document into the record. The court objection is sustained. TikToker, if you want to show him, if you have it, the exhibit, and ask him if he recalls seeing it at the time. TikToker, okay. Mr. Carnan, Your Honor, it's unclear given the fact that TikToker's using her laptop as opposed to the paper exhibits. I have questions whether this was a marked trial exhibit. The court, if you'll return to the podium, go ahead. Is this one of your marked exhibits? No, sir. Ma'am, you need... Okay. The court, okay, can you? TikToker, I'll rephrase the question. The court, that's okay. Can you please show Mr. Carnan what it is you want to show the witness to perhaps refresh his recollection? Discussion is off the record. Oh, so they have an off the record conversation. Okay. Mr. Carnan, Your Honor, I mean, I can see it on her computer. I feel that I should have a copy of this document if she's going to be asking him questions about it, as well as to readdress on redirect if necessary. The court will first, we're going to ask, Mr. Gordon, if you'll take the laptop, please, and show the witness. We'll see if that refreshes his recollection first. Mr. Ryder, for the record, does that appear to be on December 21st of 2023, an email from TikToker to you? The witness, yes. The court, okay. Does that refresh your recollection as to having received such an email? The witness, I mean, it's 2 years ago. I don't specifically remember it, but at the time I could have received it. I get a lot of communications. The court, Mr. Gordon, if you'll bring that back, and then back to TikToker, Mr. Ryder, the court, wait, TikToker, oh, I'm sorry, the court, so, TikToker, that does not refresh his recollection. TikToker, yes, sir. The court, you won't be able to read from the documents. You'll have to ask him another question. The TikToker, yes, sir. The court, all right. The TikToker, can you clarify what an inquiry is versus an investigation? So when we receive a subpoena, we look to see what's being requested, determine where within the institution that information would lie. For example, if the request is, are we talking about earlier related to courses and that sort of thing, and whether or not somebody took those, that would reside within the registrar's office. So we do an inquiry looking to see where that responsive information would be located and have those individuals try to locate it. They then provide it to our office and it's produced. The concept of an investigation is more like, for example, in higher education, you have a title, investigations, that sort of thing. You have an allegation, you have people that look into it, and then there's usually some sort of action at the end, which results in someone getting their due process. So an investigation is a much more formal process that's initiated by a complaint of some kind. Question, or TikToker, thank you. Can you clarify, did not locate communication between professor and students? In a subpoena you stated did not locate. Does that mean, because you explained what an inquiry is, that a department handles all of the emails and communication that the professors receive? Can you clarify for me what did not locate means? Answer, I believe in this situation we did a review of all of the communication that were in Professor Scofield's email account and looking for any communication between herself and any of those individuals that you listed in the subpoena. So no, nothing came back. So that's a do not locate. TikToker, did not locate also means, or question, does, that's so funny, did not locate also mean that you have access to old emails and deleted emails and did not locate them? We have a pool that we look in, which is going to be the emails. IT, the Information Technology Office, will do a look at whatever is in there. So I'm not sure what exactly you're asking. We're looking for something in a pool of information. It was not identified. Nothing came back. TikToker, I can clarify, does the pool of information include deleted emails and communications? It's possible, but in this situation, I don't know the answer to that. Question, the answer is you don't know? Well, the answer is unlikely. It's unlikely that deleted emails were part of that inquiry. I'm starting to get confused by your questions. Which fair. I mean, you're going in circles with him right now. TikToker, my question is pertaining to the subpoena, and the response I received is that the University of Idaho did not locate any communication emails between professor and the 4 students. My question is, in that inquiry, which you stated you guys looked into a pool of information, did that pool of information include deleted emails? I think by definition, if something's been deleted or you're asking if it's been removed, then if it's removed, then it would not be included. TikToker, thank you. My next question is, during investigations, you stated there was due process at the end of a formal investigation, correct? If there's some sort of action to be taken, then yes, due process is provided. If a professor, as in like Professor Scofield, was formally investigated for any of the allegations that I made against her, would she be aware of that formal investigation? Yes. How would she be made aware? Questions would be asked. If a complaint is received and we do an investigation into it, she would receive questions. She would be made aware that the inquiry is happening or while the investigation is happening. Sorry, we're using the same term two different ways. And after that investigation, what does due process look like after a formal investigation if you find nothing? If you find nothing, then the individual, there's no action to be taken, so there's no due process necessary. Well, if nothing is found after an informal investigation, will the person being investigated know that there was an investigation but nothing was found? Generally, yes. Otherwise, you're just leaving them hanging. Yes, thank you. TikToker, are you aware of a request for public records that I emailed to or I submitted to the University of Idaho General Counsel? And I can show you. TikToker, I can introduce defendants Exhibit 508 to the witness, the court, Mr. Cronin. Any objections? No objections. Will be admitted. Do you wish to publish? Please publish it to jury. All right. TikToker, Mr. Ryder, do you recognize this as an email response to a public records request to the University of Idaho? I can move it up. Just let me know. Answer, I remember your request. That is not usually. No, there we go. Did I move too fast? I'm sorry. What I'm looking at, as I understand it, I went through the portal and that we have for submitting a public records request. That is the information that's sort of structured a certain way. It's an email string. The one that was above was letting you know we would get a response at a later date. TikToker, thank you. Do you recognize that the request was me requesting information regarding the advisors for the 4 University of Idaho students and corresponding dates? Answer, I recognize what it says. Yes. TikToker, and records detailing funds received by any of the victims. Answer, yes, number 2. TikToker, thank you. TikToker, I would like to introduce defendants Exhibit number 509. Is that response? Yes. Any objection? No objection. 509 is published. TikToker, Mr. Writer, answer, is that a different one? Sorry if I'm getting ahead of you. A different request. Yeah, I didn't. It had to be. Can you move it up just a little bit, please? This way. Yeah, okay. This is the response email that I received. All right. TikToker, do you recognize this response to the FOIA request that I sent to the University of Idaho? Answer, yes. It's a request under the Idaho Public Records Act and the response. Question, can you clarify the response for the record, or if you want to shorten it, I can do that as well. Answer, what? I said, TikToker says, can you clarify that I was denied access to the records that I requested? Answer, yes. So some of the information you were asking for is regulated to be released under the Public Records Act due to the Graham-Leach-Bliley Act. The other is that there was an ongoing litigation. It was denied for those reasons that are under Public Records Act does not allow for that as a process where you have to access when you have access to discovery. And it was denied for those reasons that are under the Public Records Act as exemptions to access to those documents. Can you clarify that the one denied on the basis of the extensions was the request for advisors for the 4 students? Answer, essentially. So we can go back to the 2 questions or the 2 requests. Question, go back to this one. Answer, well, that one. Regarding question number 1, oh, okay, so we're in cross currently with Kim, and TikToker just tried to introduce defendant Exhibit 509, and this is the response of the subpoena that she submitted to get any emails or communications between the professor and the any of the victims or of the other man that she alleged was part of the killings, and then Brian Kober. So she was asking for any communications or any classes that the victims possibly had taken with her. So So Mr. Karen had no objection. The court, all right. Defendant's 509 will be admitted and published for the jury. TikToker, Mr. Writer, answer, is this a different one? Sorry if I'm getting ahead of you. A different request. Yeah, I didn't. It had to be. Can you move it up just a little bit, please? This way. Yeah, okay. TikToker, this is the response email that I received. Answer, all right. Do you recognize this response to the FOIA request that I sent to the University of Idaho? Answer, yes. It's a request under the Idaho Public Records Act and the response. Question, can you clarify the response for the record, or if you want to shorten it, I can do that as well. Answer, what? Question, can you clarify that I was denied access to the records that I requested? Answer, yes. So some of the information you were asking for is regulated to be released under the Public Records Act due to the Graham-Leach-Bliley Act. The other is that there was ongoing litigation, and the Public Records Act does not allow for that as a process when you have access to discovery. And so it was denied for those reasons that are under the Public Records Act as exceptions to access to those documents. Can you clarify that the one denied for on the basis of the extensions was the request for advisors for the 4 students? Answer, essentially. So can we go back to the 2 questions or the 2 requests? Question, go back to this one. Well, that one. Regarding question number 1, the court, just for the record, we're still looking at Defendant's Exhibit 509 now, the first page. TikToker, yes, sir. The court, all right. And then Mr. Writer, so the Public Records Act has a limitation on when there's litigation, and so that applies to both requests. The information relating to funds. There's an additional one, which is the Graham-Leach-Bliley. So both are subject to the prohibition under the Public Records Act for essentially ongoing litigation. Question from TikToker. Do you recognize or can you clarify that professor's name was not mentioned in my request for public records from the University of Idaho? Okay, yes. So this FOIA request was, can you clarify that it's a general request that is outside of litigation? Answer, I can't. I don't know what the purpose of why you were submitting the request. We knew that you had ongoing litigation that related to this, and so part of the process is to give you a denial, and then you have the ability to object under the Public Records Act. You did not do that. TikToker question, and my next question is, do you typically ask people who submit FOIA requests why they're submitting requests? Answer, no, we're not allowed under the Public Records Act to really ask much in the way of questions. It's not set up that way. If you're making a request, it's just essentially a demand for records you're entitled to. In this situation, as we understood it, you were not entitled to the records. Question, and to clarify, are you stating that I was denied the requested records, in your opinion, because I was not entitled to it because of this litigation? Is that correct? Answer, under the Public Records Act, if you're requesting information related to litigation, then yes, you're not allowed. The obligation under the Public Records Act does not trigger. TikToker, last question. Are you aware of any investigation? Thank you for this. Are you aware of any formal investigation into the statements that I made regarding Professor? Did that in turn result in Professor being formally investigated by the University of Idaho? Writer answered no. TikToker, thank you, sir. The court, any redirect, Mr. Crone? Mr. Crone, yes. Briefly, Your Honor. The court, all right. And then we hop into the redirect. So this is the redirect from Mr. Crone. So Mr. Writer, you were asked some questions about the distinction in your mind between an investigation and an inquiry. Do you remember that? Yes. Is that distinction something you know as an attorney in the General Counsel's office in the University of Idaho? Yes. Are professors generally responsible for responding to subpoenas directed to the University of Idaho? Answer: I would say I can't think of an instance where we would have them respond. Question: so would a professor have a reason to understand the distinctions that you, as a lawyer, make between inquiries and investigations as it relates to subpoena responses? Answer: no. Mr. Crone, let's pull up Exhibit 28 again, please. Your Honor, may I publish Exhibit 28? It's already been admitted. You may. And then back to Mr. Crone. Mr. Ryder, I'd like to direct your attention to question number 8, which is on the second page of Exhibit 28. Please read question number 8 aloud. Answer: all right. Please produce any communications indicating or suggesting that professor has or had attempted to delete, remove, hide, or otherwise restrict access to communications and or transactions involving any of the aforementioned student. And then it's all the students, the ex-boyfriend, and Brian Koberger. Did the University of Idaho review all of its documents, communications, and records to respond to, available to it at this time to respond to question number 8? Answer: I wouldn't say we reviewed everything that made sense to review in this. We didn't, for example, go through the library and look at every book we had a lot of documents. Question: fair enough. So anything that would potentially be responsive to question number 8, University of Idaho would have reviewed. Answer: yes. Did University of Idaho find any documents or evidence suggesting that anything had been hidden or removed or deleted? No. I'll direct your attention to question number 10. Can you please read question number 10 aloud? Please produce all communications indicating or suggesting that counter-defendant professor has or had attempted to delete, remove, hide, or otherwise restrict access to information regarding her connection to any of the aforementioned students. And then all of the victims, the ex-boyfriend, and Brian Koberger. Question: similar to with question number 8, did the University of Idaho review any of its potential relevant documents and records to respond to question number 10? Yes. Did the University of Idaho find any evidence of deletion or removal? No. And finally, exhibit number 509. This was also previously admitted, Your Honor. Do you remember TikToker asking you questions about exhibit 509? Yes. What's the date of 509? October 21st of 2025. Is this after this lawsuit was filed? Yes. Was that, I believe so, yeah. Was that after TikToker had already subpoenaed the University of Idaho? Yes. Why did the University of Idaho not respond to this public records request? Answer: primarily because there's litigation ongoing. The Public Records Act is not set up to be a substitute for discovery. Did the University of Idaho fully respond to TikToker's subpoena, which was a proper discovery tool in this case? Say that again. So, exhibit number 28 earlier, that was the University of Idaho's response to TikToker's subpoena. Oh, right, okay. Is the subpoena what you're referring to as a discovery tool? Correct. When you're saying, and did the University of Idaho respond to TikToker's subpoena? Yes. Mr. Crone, no further questions, Your Honor. The court, all right. May the witness be excused, Mr. Crone. Mr. Crone, yes, Your Honor. The court, thank you, Mr. Ryder. You may be excused. Mr. Crone, if you'll call your next witness. Mr. Crone, I'd like to call Sean Quinlan, Your Honor. And then the witness is sworn in. Please state your name for the record. You may inquire. Okay. Direct examination of the Dean of University of Idaho. So, good afternoon, Mr. Quinlan. Good afternoon. Do you have an undergraduate degree? Yes, I do. From where? Arizona State University. Do you have any graduate degrees? Yes, I have a master's degree and a doctorate from Indiana University, Bloomington. Hey, I know that one. I'm from Indiana. I know exactly where that place is. I almost went there. What years, if you remember, did you obtain those degrees? Arizona, I believe, was 1992. My doctorate was 2000. Have you worked in academia since receiving your PhD? Yes, I have. Where do you currently work? I work at the University of Idaho. How long have you worked at the University of Idaho? Almost 25 years now. What's your current title at the University of Idaho? I'm an academic dean. I'm dean of the College of Letters, Arts, and Social Sciences. As the dean of the College of Letters, Arts, and Social Sciences, do you oversee the history department? I do. The history department is one of my departments, yes. How long have you been in that position as dean? Going on 9 years now. Do you know Professor? Yes, I do. How do you know the professor? I've known her for almost a decade now. I was chair of the history department when the University of Idaho originally hired her. In your experience as an academic and as a dean at the University of Idaho, are academics evaluated based on their research and teaching? Yes, sir, they are. How important is reputation to an academic's abilities to succeed as a researcher and a teacher? I would say it's extremely important. Why? It's a variety of factors that go into that. I believe it's it is where one received their training originally. It's the rank of the institution that one works at. It's the record of publications that they've accumulated over time, honors, distinctions, much in, I would say, in academia. It is done through committee work in which faculty or administrators grant panelists if they work for the federal government or state agencies are assessing people's work, looking at their dossiers, looking at their curriculum vitae, looking at their scholarly productivity, one's reputation, reviews that come in on people's work. So one's status, I think, in terms of how people in the field look at one's career is extremely important for the present and also for future opportunities as well. Does an academic's reputation affect which universities will hire them? Yes. Does an academic's reputation affect which publishers will work with them? Absolutely, yes. Prior to November of 2022, how would you describe Professor as a teacher? She's an excellent teacher, and I think that when University of Idaho originally hired her, one of the things we saw great potential in her as a researcher. We saw great potential to her as a teacher as well, in her work, her ability to interact with students, and the repertoire that she developed with them, the fact how she could get them to think, to engage in the subject matter. As someone who practices history myself, it's really impressive. And, I think her work and her ability to inspire students about history and to get them to think about the past in, new and creative ways is deeply moving to me. You touched on this a little bit, but prior to November 22, how would you describe Professor as a researcher? She's top notch in her field. She came into the University of Idaho with great credentials, a great background. We had great hopes, particularly as a chair and as a department, that she would excel in her academic performance. When she came, she didn't disappoint at all. She published, she got a book out, which is kind of the gold standard in our field, is the key in someone being able to come up for tenure and promotion. She received a very prestigious Whitting Foundation Fellowship for outreach, as it was doing all the things, I would say, as someone that could work at any top-notch institution in the country. Prior to November of 2022, how would you describe Professor as a person? She's a great colleague. She's a great colleague, engaged in everything she's doing, engaged with teaching, with research, with service in the unit. Someone I would call a good citizen in the department, someone who volunteers and, does all the grunt work that people don't want to do in terms of sitting on committees, sacrificing time, going to outreach events, weekend stuff. She had a great sense of humor, thought long and hard about not just the history program, but our academic college, our university. I would say as a colleague, it's just, absolutely stellar and the type of person you hope to hire at an institution. Prior to November of 2022, are you aware of anything about Professor's reputation that would have negatively impacted her ability to succeed as a historian? No, none whatsoever. Dean Quinlan, were you living in Moscow, Idaho in November of 2022 when Brian Koberger murdered 4 students? Yes, I was living there. How would you describe the atmosphere in November of 2022? I would say first and foremost, it was a community that was mostly grief-stricken and in shock in that, that something that terrible had happened. The sense of loss over four young people's lives. It hit the community, hit the university. The outpouring of grief was unbelievable. And so there was that immediate, I think, sense of grief and loss. There was makeshift shrines that were developing all over the town, at the entrance to the university, at the restaurant where at least one of the victims had worked. There was just this outpouring of grief. There was deep concern and panic in the community and the fear that there could be a murderer among us, that that killer might strike again. There was a huge sense of insecurity that went along with it. People were afraid to go outdoors, people were afraid to go to class. There was that there was a real sense, I think, of invasion that happened as well with the media. Journalists who came into the community, and that kind of made the sense of grief and paranoia even worse. And I think there was something you'd stop people on the street. That's what they talk about. I think the concern was it was it was very intense. That's the only way I can describe it. Thank you, Dean Quitland. You mentioned this sense of fear and panic in the community. Did you observe anything about how people responded to the doxing of suspects online, kind of in this immediate aftermath? Which, by the way, don't do that. don't dox people. That's so rude. They're just living their life. I get that you want to have like answers to stuff and everything, but why are you doxing people? That's nasty. Anyway, I don't have time to listen. Well, when you get a chance, enjoy them. They'll be up. I'm fixing the other one right now, so apologies. Answer yes, and I think there was real concern, my memory of it is that were a number of people who kind of emerged of interest in social media or in the news. An enormous amount of kind of speculation evolved around that. And for one, I understood is a lot of insecurity for those people who were targeted, concerns about their personal safety, their privacy, their ability to kind of continue on afterwards. And I think that, members of the community and people I was speaking to, they were dismayed and shocked by that. Do you remember Thanksgiving Day in November of 2022? Yes, I do. Were you Professor Scofield's dean at the time? I was. On that day, did you learn that TikToker was posting about Professor? Yes, I did. Were you concerned at the time about Professor's safety? Yes, I was. Why? Given all the media and paranoia around the murders, I was very concerned about her safety and their privacy, or her privacy. Whether she could be a target of some kind of vigilantism in worst case scenarios or having her house overrun with media. Yeah, so I was very concerned about her well-being. Did you call campus security or the police because of your concerns? Yes, I did. Why? I was first of all trying to alert anybody or somebody and to let security know that there could be issues. And I wanted to make sure, Professor works in our college. A sense of responsibility as a colleague, as a member of our community, is to make sure we're doing everything to keep her, safe and sound. Did you talk to the VP of Information Technology at the University of Idaho that day? Either on that day or the following days. And why did you speak to that person? Well, since it involved social media, since it involved, Professor had a web page, there's information about how to get a hold of her office location. I was also looking for information if there were if someone was being the target of kind of salacious defamatory attacks. Is there anything that we could do in terms of technology to respond, to shut things down? Could we help in any way? Did you ask to have Professor's webpage taken off of the University of Idaho's website? Yes. Why? It is that so that her personal information, how people could find her on campus, her classroom, where she taught, where her office space is, that would become private information. So if we did have people who were looking to find her, that they would have a tougher time doing so. Did you consider whether to have Professor teach remotely to help her stay safe? Yes. Did you also call the director of communications for the University of Idaho? Yes, I did. And why did you call the director of communications? To inform, her name is Jody Walker, to inform Jody Walker that this was going on. Also to get information as to how the university could respond to one of our colleagues who was also being targeted on social media, how we could potentially help awareness as well, that if it became a media issue that we would know that one of our employees was being targeted, would be targeted in such a way. And also in my, limited understanding of social media or how to respond to it, was trying to get as much information to help a colleague as possible. Oh, goodness. Is it fair to say that you called a lot of people at the University of Idaho in response to TikTokers' posts? Yes. This was a situation you were taking seriously. The situation was taken very seriously, yes. Immediately following Thanksgiving of 2022, how often were you checking in with Professor? In the weeks through the Christmas break, I would say we were regularly checking in, whether it was every day or every other day, but we were connecting very frequently. Find out how she was doing, if there was news, just to check in on her general state and also to inform her of any developments I was hearing on the side of the university as well. In the November-December 2022 timeframe, did you personally observe TikTokers' posts causing stress for Professor? I saw a handful of them. I'm sorry, did you see it causing stress for Professor? I'm sorry, yes, I absolutely saw. How did you observe? What I would say probably described as physical manifestations of stress, anxiety. Our conversations were always about the worry about personal safety. It was the worry about, logistics at work, the impact about professional reputation. I mean, at some point, this was in The Guardian. I mean, it was an international news. You can see it in the terms of exhaustion. I was very concerned about how she was holding up under what seemed to me extremely trying circumstances. Did you observe that stress making it more difficult for Professor to continue to perform as a professor as she had prior to November of 2022? It seemed to me that everything she was doing was taking enormous effort and everything had to be kind of above and beyond what I would consider to be a kind of reasonable expectation of duty. And the 3 years since then, have you continued to observe Professor needing to strain or work harder to perform how she did prior to November of 2022? Yes, the same, I think. Kind of sense of exhaustion, anxiety, worry, I think had been apparent in our conversations, in her comportment, in her demeanor. There's very few. She's a department chair. We have regular work meetings together, check-ins, visits in departments talking about all the range of, academic business that we have in our units. And, this habitually came up in all of our discussions. I would, ask, try not to be invasive, but how are you doing? Are there things we could be doing? Is there anything I could be doing to help? So, this is something that I think she has carried with her heavily over the past 3 years. Question, as an academic and a dean, do you have experience with how professors are hired by universities? Dang, my dyslexia is kicking in. Yes. As an academic and a dean, do you have experience with how professors are promoted into leadership positions at universities? Yes, I do. Do you have any concerns about the long-term effects of TikTokers' posts on the professor's career? In my professional estimation, yes. What are your concerns? It is, if I may preface by saying, I think Professor Scofield is an extremely talented teacher and historian, and I think she is, based upon her skills, she has enormous career opportunities ahead of her. I mean, I would hate to have her leave the University of Idaho, but she has an enormous amount of potential in terms of her skills or her abilities. And, as someone who under most circumstances could probably, very easily write the next stages of their career and make all sorts of choices. And having said that, is that I know being a professor or being in leadership roles in universities are very public roles. There's a lot of vetting that goes on behind that. Institutions I think, are very concerned with their image, with the background of the people that they hire. There are things that get looked into, they get scrutinized really carefully. And so if someone were, trying to, have like, other opportunity at an institution for promotion, for greater salary or career opportunities, someone that, in which there's material on the internet or background information, is that that material could circulate and really impact the decision making of a hiring committee as well. He says you know a lot. Oh my goodness. For someone in a leadership role as well, it is that people, habitually look into their Google past or look them up, and people will ask questions about their past. It could very well be is that institution is like, there's too much liability for me or concerning about hiring. We don't need that type of publicity. We don't need our marketing or communications team worrying about this. So yeah, it could very well be that is the long-term impacts of this in terms of someone's career potential, their earnings. It is, it's going to be part of their reality moving forward. And if someone is kind of has that background, there's going to be something constant. They're going to have a script for that at all times. They're going to have to answer questions and be prepared to explain it in ways that, would be extremely professionally degrading and humiliating. Humiliating. I can't speak today. Oh my goodness. Oh my goodness. Okay. Thank you, Dean Quinlan. No further questions, Your Honor. The court, all right. Any cross-examination? TikToker, I have several questions. The court, you have what? TikToker, I have several questions. Just begin anyway. The court, yes. How long do you think you'll have? 20 minutes. The court, all right. We'll get started. I don't know that we'll finish. Oh yeah, because they were running into like 3. They had to be out by 3, or had to be done by 3. Or that's what they said, at least. So, and this is cross-examination by TikToker. Good afternoon, Mr. Quinlan. Good afternoon. You stated you have been professor's boss, but stated you've known her for a decade. How long have you been her boss? I was department chair when she was hired for 6 years, and then I supervised her in the capacity of chair in the, I think, 4 or 5 years since she became a department chair. 11 years, a total of about 10 years I've been working with her. Regarding professors' performance during that time, you stated she was excellent, top-notch in her field, correct? Yes. And today, as of today, and after November 23rd of 2022, she's still top-notch and excellent in her field. She's the top-notch, excellent academic. As a result of the accusations I made against her and posted TikTok videos, as her boss, did you ever feel the need to demote her, investigate her, or punish her in any kind of way? No. When you said that this could impact her future professional career, you were speculatively speaking on what another institution could do. At the University of Idaho, does Professor have a promising future? I think she has great potential ahead of her. How the social media background may impact opportunities for leadership roles down the road, it would be difficult for me to say. Question, on November 23rd and 24th of 2022, when you became aware of the accusations I made against Professor, was it your intent to use that information to negatively impact her career as her boss? Answer, I'm sorry. Could you repeat the question? Question, I'm sorry. Answer, no, I apologize. TikToker, at the time of the videos, did you feel the need to punish Professor or limit her opportunities at that time? Answer, no. Question, why would in the future, because you said you just made a statement stating that the University of Idaho or any leadership positions she could be scrutinized for because of the videos. If at the time of the videos she was not scrutinized or limited in any kind of way, what would change in 10 years per se, or in 5 or another 3 that would change that to make her then in the future be scrutinized? I don't know why my nose is so itchy. I think he was more talking about, like, if she were to leave the university, then it could be a fight, like a big deal. But with them already knowing what was going on, I don't think it would be like a massive deal for her now, but it would be in the future, and it technically in future opportunities too, if she were to write like another book or something of that nature. Quinlan answers, I think that would be I think that the impact would be in a very subtle ways, actually. In very subtle ways, actually. Is that in where people might be in a public role and you have search committees and you have colleagues who are together and who may be looking at individuals that have, for lack of a better word, external facing roles, and that they become the public face for the institution, that they may have second thoughts or concerns that the individuals that they're someone in that position is that questions may be about their social media background or what they find in the internet more so than the business at hand at the university. For instance, if someone's in the role of a dean, in which one of their big roles is actual development and cultivating relationships with alums and stakeholders, oftentimes for the purpose of trying to raise money for our students, and that if these conversations are consumed with someone's social media past, they have to answer questions about what really happened, or going back into the past could potentially become a big distraction in those conversations, and could really potentially negatively impact someone's, we don't want to touch this right now. We'll go with someone safe here, or we won't explore this further. So I think that is kind of on the level of where the concern was. And Mr. Quinlan, this example you just gave is based on a real person or just speculation? Are you speculating? I mean, you're going to have to speculate, because unless you have documented proof of someone being accused of murder and then going through all this and they work in academia, I mean, you're going to have to speculate. Answer, not to bring in too much of my own personal information actually, but in my history as a professor and as a dean, twice in a very small level, I was subject to kind of social media attacks, and they were because of things that I was involved with in terms of the history profession, my writing at the time. And some of that, for instance, happened 21 years ago, and I will still get emails about that, and I will still get questions about it, and sometimes in very unexpected ways. And so, even though it may be 20 years ago, that material has a life on the internet, and it comes back and is an object of discussion, and people ask, well, what happened there? Or can I go back and look more about that? I'm just interested, and it becomes a professional distraction. Question, this alleged event you're speaking of that you experienced on social media, you said 20 years ago, correct? Yes. Question, how long have you been a dean again? Can you restate how long? Almost 9 years. 9 years. So 9 years ago, you reported to dean at the University of Idaho despite the online speculation from 21 years ago. Is that correct? Yes. Over the past 3 years of this litigation, has professor been promoted or received a salary increase? I'm thinking of the timeline is yes. Has she been promoted or received a salary increase several times, let's say annually? I apologize for saying this. I can't remember what years that might have been, but it's been multiple years. 2 years if there was one. It was one occasion, I believe. Did my online videos prevent professor from any promotions, salary increases, opportunities at the university? Not under my watch, no. The court and TikToker were at 3:01. If you have, say, another 10 minutes, you can finish up today. TikToker, yes, sir. The court, is that okay? TikToker, yes, sir. The court, rather than bring Dean Quinlan back again, will finish up if the jury will accommodate us. TikToker, after November 13th of 2022, did you work closely with the professor between November 13th and November 22nd? Yes, we were in frequent communication. Yes. How would you describe her demeanor and behavior or response around that time to the TikTok videos? Or that was so November 13th. That's unfortunately when the students were murdered. And I'm asking between November 13th and November 22nd before the TikTok videos. Before I apologize for my interactions with her would have been routine daily check-ins. So I would do with all as I would do with all department chairs in my unit. You stated earlier that after the murders, the staff and the environment at the University of Idaho was, panic in the community, fear, insecure. Is that correct? Yes. Was professor in that community and also panicked, fear and worried about her safety. She expressed many of the same concerns as about personal safety. I would say that and concern over students and her fellow students that were exhibited by many other faculty members that I was working with at the university. Question: after the TikTok videos, did you see an increase in distress? Yes. Different from that after the murders? Absolutely. If you have to compare her demeanor after the murders versus her demeanor after the TikTok videos, would you say she was more distraught about the TikTok videos than she was about the murders? I get the line of questioning, but that's kind of a weird way to put it. Answer: I would say that in addition to the shock and grief of the murder of the students, was added an element of concern over personal safety and vulnerability due to social media exposure. Question: after the murders, were there any other professors in your department or generally at the University of Idaho that were moved to online classes versus on-site classes? Answer: there were several faculty members who for very different reasons taught online, and there were opportunities that faculty gave to their students as well to give them more flexibility in terms of whether going to class or learning remotely in order to accommodate the sorrow in the community and also the sense of vulnerability. After the murders or on November 13th or before, did professor teach a class on site at the University of Idaho? I'm sorry, could you repeat the dates for me again, please? TikToker before or on between November 13th and November 22nd before the TikTok videos, did Professor Scofield have a class on site at the University of Idaho? My recollection is that she was teaching an in-person class. And that in-person class after the murders was professor offered the opportunity to move her classes online. Yes. You stated you did everything to keep her safe and sound after the TikTok videos. Would you say you also did everything to keep her safe and sound after the murders? Answer: yes, in terms of level of care that we were exhibiting to or trying to give to all of our colleagues and students. Question: you described Professor being grief, anxiety and things of that sort after the videos. Are you describing those symptoms as are you a psychiatrist? Ma'am. Oh my God. Okay. Oh, Lord. Answer: no, just out of being a concerned colleague. TikToker: do you know the diagnostic criteria of anxiety? Not as a psychiatric professional. No. So you were just guessing or estimating based on layman's knowledge. I get why she's asking that, but that is such a okay. Answer: based upon what I've seen, the individual's under extreme stress at a particular moment and, on level of, just trying to care for another person. TikToker, and last question. You said that my TikTok videos against Professor, you said the situation was taken seriously. I want to clarify. By seriously, did you mean that you were keeping her safe and told her what to do to protect herself online? Is that what you mean by taking it seriously, or do you mean taking it seriously meaning investigate it? Answer: I meant that we were concerned that the videos may create upward attention towards her from either media or random vigilantes, and that we wanted to make sure that one of our colleagues, had as much protection, personal protection, as possible from random danger that could be generated. TikToker, sorry, one more question. Sure thing. TikToker, thank you for reminding me about the vigilantes and being overrun by media. Oh my god. It's been 4 nearly years since the posting of those videos. Are you aware of any vigilantes that has went after the professor? No, I'm not, fortunately. Are you aware of her home being overrun by media? Not that I'm aware of, no. TikToker, thank you, sir. The witness, yeah. TikToker, no more questions. The court, thank you. TikToker, Mr. Carone, any redirect? Mr. Carone, very briefly, Your Honor. The court, all right. And then we go into redirect. Question, Dean Quinlan. You were just asked whether you were aware of any vigilantes who had reached out to the professor. Do you remember that? Yes. Are you aware of any TikTok artists who had continued to post? Are you aware of any TikTok artists who have continued to post about the professor and accusing her of being a murderer and having a relationship with a student? I'm aware of that. Yes. Oh, who have continued to post about. Okay. Answer, I'm aware of that, yes. Mr. Cron, no further questions, Your Honor. The court, may the witness be excused. Carone, yes, Your Honor. The court, thank you, Dean Quinlan. Thank you, Your Honor. You may be excused. The court, thank you, jurors, for your extra patience today. I failed you by 10 minutes, but maybe we'll make it up tomorrow. I repeat that same admonish to everybody that I gave last night as well. Not to see, hear, or read any reporting of this case. Do not have any contact or communications about this case with anybody. And if for some reason you do get exposed or someone tries to contact you about the case, please report it to me first thing in the morning. With that, have a good night, and we'll see you all tomorrow at 8:30. The jury will be excused. And they exited the courtroom. The court, please be seated. All right, Attorney Olson, as I mentioned, I wanted to briefly give you the opportunity to address TikToker's 3 jury instructions that she filed last night and give your position on those before you have the informal conference with Mr. Gordon to wordsmith the instructions that I put together. So let me hear from you if you wish. Oh, didn't mean to bump that. Miss Olson, can we just have a moment, Your Honor? The court, yes, I know we're moving along. I have a 3:30 is the only reason I have to get moving. Mr. Carone, sorry, Your Honor, we just got these late last night, so we haven't had a lot of time to meaningfully process them. But just to address them in order, so the mitigation instruction. TikToker identifies the pattern jury instruction. Candidly, I've not had an opportunity to confirm that this entirely mirrors the pattern jury instruction. If it does, we have no objection to using the pattern jury instruction for the damages. The punitive damages, the second instruction, we would object to this on several bases. The first being there is a Idaho pattern civil jury instruction on punitive damages, which would have been what we included in our submission. The rule's pretty clear that when there's a pattern instruction, generally you're supposed to have some difference to that. I also think TikToker is kind of mixing up the pretrial standard for punitive damages versus at trial, and that there's a process that the court has to go through to consider evidence when granting relief to seek punitive damages at trial. I don't think that process would be applicable to what's then actually given to the jury at that point. Excuse me. There's a separate part of the statute that addresses when the jury may award punitive damages, and I think that anything that goes to the pretrial leave to seek punitive damages would not be relevant or appropriate here. And finally, on mental health damages, again, I haven't had time to verify this, but looking, she's not citing a pattern jury instruction. She, I think, is just cherry picking an Idaho code section on something that is totally different from what we're here for in this trial, and also that there are other multiple ways to show mental health damages or non-economic damages. And so we'd object to this mental health damages instruction as inappropriate. The court. All right, TikToker, do you have any response to that? TikToker, my only response is in regards to the mental health damages. Mr. Crone said it has nothing to do with this, but PTSD has been mentioned several times during this litigation. I wanted some type of instruction for the jury as it pertains to how to calculate damages for that. Additionally, The court, before you move on, are you still arguing that particular instruction? TikToker, yes. The court, okay, go ahead. TikToker, that's pretty much what the court. All right. So that Idaho code section, that is the standard for workers' compensation to grant workers compensation for PTSD. It's not a jury instruction. That I believe is applicable in a case like this. So I don't think it would be something that I would instruct the jury. You're certainly able to argue that point, but absent a pattern jury instruction in Idaho law that's applicable, that is just a code section that deals with if someone has PTSD, whether they get workers' compensation and the standard for them doing so. I don't know if Mr. Crone, if you have anything else to add to that point. Mr. Crone, not on that third instruction, Your Honor. The court, do you have something to add on another instruction? Mr. Crone, just briefly on the second instruction. Again, the punitive damages one. I just realized that she had cited to. It looks like she's citing to the Ninth Circuit pattern jury instruction, at least in part. In this situation, because we're in diversity jurisdiction, the Idaho Code is a substantive law, so the federal court is applying Idaho law, which is why the Idaho pattern jury instruction on the punitive damages statute would be the more appropriate instruction to give in this case. The court, so TikToker, and then TikToker, no objection to that. The court, and we will have a standard Idaho punitive damages instruction under the Idaho model jury instructions. And then, do I understand that, Mr. Crone, if the instruction as to mitigation is accurate, that you don't have an objection to that? Mr. Crone, that is correct, Your Honor. The court, all right, okay. Mr. Gordon, did you get all that? Yes, the court. So then, TikToker doesn't object to the Idaho pattern punitive damages instruction. Mr. Crone does not object to the mitigation instruction, and absent a pattern jury instruction as to the mental health damages. The one that TikToker has submitted, we will not include because it is the legal standard for a workers' compensation claim, and that really doesn't apply in this case. All right, so what we've done, counsel and TikToker, is we've put together a court's draft final jury instruction. Mr. Gordon is going to meet with you all in the courtroom now, provide you with our draft. Are you ready to do that, Mr. Gordon? I'm going to need to make some changes, the court. So maybe in about 10 or 15 minutes. Mr. Gordon, yeah, I'll need to print them off, also the models too. The court, and Mr. Gordon is going to print out the relevant model jury instruction templates for the Ninth Circuit ones and the Idaho ones so that counsel and TikToker can see how it is that we modified them. And then if there's any wordsmithing that parties want to do based on our modification, you can certainly have that input. But Mr. Gordon will take that down, and then we'll address that later tonight and have a final set for you tomorrow. And like I said, then we'll have the formal jury instruction conference with me where you can object to what my final instructions say. Any questions about that, TikToker? TikToker, no, sir. No, sir. The court, any questions, Mr. Crone? Mr. Crone, no, thank you, Your Honor. The court, all right. Anything else, Miss Olson, Mr. Crone, that you want to bring to my attention today? Miss Olson, witness order for tomorrow. We had to make a few shifts because we've gone a little slower than I anticipated. I think we anticipate that we will call Rebecca Talent, Rebecca Bond, Chris Hansen, John Carlson, and Margie Scofield. The court, as is. And is that all of your remaining witnesses? Miss Olson, it is, Your Honor. The court, all right. And do you anticipate that we'll get through them all tomorrow? Miss Olson, we hope so, Your Honor. The court, okay. So, Ms. Gulliard, you ought to be prepared sometime later in the day for your case in chief as well. We won't take any break in between the plaintiffs finishing their witnesses, if they do, and resting their case. We'll go directly into yours unless there's any legal motions that are made, but we'll just jump right into your case in chief, and so please be ready for that. Again, the questions that you want to ask yourself and testify to in your case in chief, I want to make sure they're not cumulative of what you've testified to today on cross-examination, so try to pay some attention to that. I'll give you some latitude, but I don't want a repeat of the same question that the jury's already heard. Any questions on that? No, sir. The court, okay. Anything you want to bring to my attention, housekeeping housekeeping wise or otherwise. TikToker, no, sir. The court, okay, all right with that. The court will be in recess. And then proceedings concluded on 3/21 of February 2025.